Department of Ag.
Department stands on its testimony supporting the intent.
Thank you very much. Department of Health. Budget and Finance. Ahomoku Advisory.
Ahomoku stands as testimony of opposition to council.
Thank you very much. LERP. Waimaoli.
Stand support of intent.
Thank you. Hawaii Farm Bureau.
Stand our testimony.
Oh, thank you. State Procurement Office. Yeah, that's here anymore. Let me see. Hawaii Green Grove. That's all the written testimony. Okay, now questions, members. If not, let's move on to House Bill 2501. Okay, so with 2501, this is what we want to do. Because we have about 3 inches full of testimony instead of going through, or more like 4 inches, instead of going through all the names, I'm not sure who's here. So what we're going to do is whoever want to testify, identify yourself, and then come up in an orderly fashion and fill up the 2 seats in the testifying chair. If I could ask for your assistance, and when one person finishes testifying, if the next person could come up and sit in that seat so that we can have a orderly fashion to deal with these issues. So first, whoever wants to come up, first come first. And then whoever next is, I want 2 seats filled all the time. Okay, go ahead.
Aloha. My name is Lucy Andine. I live in Puelo, which is one of the lease areas that is referred to in the licenses. That is part of this proposed language change. I would like to ask this committee to not forward this bill, to vote it down. It really isn't necessary. It's going to prolong something that has lasted too long already. Our situation in Puelo is that we have no public water supplies. The streams are our lifeblood, and we joined in 15 years ago asking that the stream flow be amended, following the laws, being patient, trying to do things the right way. After 8 years, we finally got our day at the Water Commission, and a decision was made to return a very small amount of water to our streams. We have folks there that have kuleana rights, riparian rights, and pipe rights from their deeds from the 1920s with HCNS, when HCNS bought out the old Puelo sugar plantation and then divided up the lands. But we don't have enough water to fulfill all of the water that's legally available to folks, even domestic water. So we have people fighting over the pipe rights, and our dream would be to have enough water that we could have 2 community pipes rather than 1. And that way we could have like 10, 11 families on one and 10, 11 families on another, instead of like 20 families all, trying to go out of a little like 2-inch pipe that's in a pond and a stream that sometimes has water and sometimes doesn't have enough water. What does that have to do with this bill? Well, we want there to be consequences. We want A and B to share the water. We are willing to share the water. We've always been willing to share the water. Just right now, our share is very, very small. Same thing with our neighbors from the Po Valley. They're part of the Puelo lease area. They couldn't come today. A lot of folks from my community couldn't come today. People are busy with their families and their work. So I'm trying to speak for the 50, 60 people who live in our valleys. We have about 7 streams in our valley. We're only asking for water back from 1 and 1 tributary. It's not selfish, really, but if you allow this whole lease thing to continue year in and year out with no consequences, we'll die waiting for water. I'll just be blunt. It is not, you need incentives to work things out the right way. And if you just have like a blank check that, yeah, your permit's good for however long and whatever because you applied for a license once, well, the law says that folks in our neighborhood are supposed to have riparian rights. Mr. Solomon Lee, my neighbor, who has his land from the Mahele, is supposed to have enough water to grow Kahlo just like his tutu did, but he does not. And he's asked everybody and begged everybody, other neighbors the same way. We really need a solution, not just kicking the can down the road. So we ask you, please, say no to this bill. It will not affect our county farmers. You're going to hear from the Farm Bureau. You're going to hear from farmers. They have an exemption from the court. So I cannot believe that there's not a way that A and B could get water to them, because, first of all, their water lines, a lot of them are very separate from the big ditches that go to the sugarcane fields. It's kind of complicated, and I won't go into it because you folks, don't have endless time. But that is really kind of a smoke screen. Those ditches can't be shut down overnight. There's just no mechanism to do it. And I've heard folks say that returning the water to the stream is like a waste because it's just going to be eaten up by weeds and stuff. But, we've cleaned our stream beds, but then there's not enough water flowing to keep them clean. If we knew there was water coming back, we'd clean them. And the communities want to make this work, but you've got to have something starting at the top. So please hear from the folks that we don't hear from very often, and we're here to ask you, Kokua, turn this down. Mahalo.
Thank you. Next testifier.
Thanks for the opportunity to testify. My name is Michelle Galimba, and I have a ranch in Hawaii, on the Big Island, and we have an RP. We live in, just like the previous testifier, we live in a very remote area, and the RP that we have, the local permit for water, is the only way that we can get water for our ranch and neighboring ranches. So it's really important that you pass this bill, because you would be cutting off the water supply for dozens of farms and ranches, as well as homesteads in Ka'u. So this is a really complicated issue, I understand, but it will not passing this bill will also have really big impacts in my area in Ka'u. My ranch is a family ranch, and we grow local beef for food land and Whole Foods here. So if we don't have water, we can produce food for our local markets. We don't take any water from streams. We only use water that was developed by the plantation from tunnels, so it's not taking surface water at all. We would have preferred to have a long-term lease, but local permits was what DLNR was working with. We talked with them, so that's what we have, and it would be it's really bad to take away even this very short-term tenure that we have for our land, for our water. So as I said, this is a really complicated issue, but we just want you to know that there's impacts. We can impact local agriculture by not passing this bill, so please do pass it.
Thank you. Next testifier.
Aloha, my name is Dr. Kalama Oka'aina Nihau, and while I don't speak for the following organizations, I'd like to give my perspective for somebody who has been a physician for Onipa'ana Kalo, which is the Taro Farmers Association that supports kalo farmers throughout all of Hawaii, as well as the convener for the Aha Lo'aina, which is the alternative Aha for governance for our Kanaka Maoli people. And so again, I don't speak for these two organizations. I just want to explain for myself, I was dedicated for the past 20 years of my life, the entire time that I've been an adult, for one, to supporting our people, and also for particularly supporting our kalo farmers. We're looking at a situation where there's a crisis happening, and I want to put into two contexts. One is as a physician, okay? So you look at kalo. Kalo is one of the most complete foods that you can have. You can eat every single part of the food. There's also no documented history of an allergy ever being developed because of kalo. That's really almost impossible to find out of any food. You have a lot of kids people are having peanut allergies, all these different allergies. We don't understand really what's happening there, but there's no documented history of kalo causing allergies among our people. And it's also incredibly, the studies have shown, it is incredibly tied to the health of our people. Now, not just Kanaka Maoli people, we're talking about people throughout the globe, okay? We're talking about a healthy, sustainable food and food system that provide for really a future throughout the world of potentially feeding the world. It is the highest yield crop per acre out of any crop that you can have. It utilizes an ecosystem, a process that actually returns water, that returns support to our ecosystem. It doesn't destroy it, it actually builds it and makes it better. And so for our kalo farmers, the thing is, what has happened? We don't have land, we don't have water. And so in order for kalo to flourish, in order for it to be fed and be available, the reality is that all of these waters were taken away for development and for big business, right? So in order for the kalo to flourish, there needs to be water. But it doesn't just apply to the water. We're talking about a growing epidemic throughout the world where people are actually dying of obesity and diabetes at unheard rates. Obesity has now exceeded smoking as the #1 leading cause of preventable death. The #1 leading cause of preventable death. I'm seeing 12-year-olds coming into my office with diabetes. I'm seeing 20-year-olds, and we're not talking about people on ice, we're talking about people who are eating McDonald's and rice and all of these awful foods that are out there where they're having heart attacks and they're going on dialysis. This is unheard of. This public health phenomenon is unheard of. And then you go and find out, where can you get kalo? How much does it cost? What is it available? We need, in order for this crop to be grown, takes a full year. And we're talking about water, infrastructure. We're talking about people who I consider the working wounded. Working wounded in Hawaii are so common. They work maybe 3 jobs, 19 hours here, 19 hours there, 19 hours there. None of them with health care. Our kalo farmers are working 60, 80 hours a week. They make a little bit too much to qualify for Quest, but they're doing it for love of our people. We have a public health epidemic happening here. So unless there is a priority that happens that puts the kalo farmers first, and if you look back, the brilliance of our ancestry, there is a reason why in the legal and the laws, kalo farmers have a pertinent water rights. A pertinent water rights because without the kalo, without the water, there's no kalo. Without the kalo, there's no Kanaka Maoli. And we have to maopopo that it's not just Hawaiian people. Going on to the political aspect of things, okay? Talking about an ike that happens to go throughout the world. Currently, we're looking at a climate change crisis in which,
we're on 2501.
yes,
So it would be helpful initially if you state your name and your position, because I still don't know.
so are opposing the
So
water.
you can continue. But out of respect for everyone, if you keep your comments not more than 3 to 4 minutes, because there's a lot of people waiting still, and I know people have to catch their breath. So yeah, with that, continue on.
Thank you very much. I was just about to close up. I wanted to say that we're looking at a climate change problem that's happening. Really, literally, the world's almost going up in flames. We have a situation where we have to really deal acutely with how we're going to look at the future and how we're going to be dealing with how we look at resources and food and how we're going to feed the people. This water process that we're looking at, the way it's built it's uniquely very well built for Hawaii. It's not just the kalo farmers, it's also the Lavaia, because the water that goes through is not wasted. Back in 1996, when you first started this struggle, you turned the water first back to the Waihale ditch. They all said it was wasted. It was wasted if you put it into the water. But we now know the water return actually restores the estuaries and actually cleans the reefs and actually improves the fishing quality. So this is a global picture. So I ask you to step outside the box and please, return the water to the Maui farmers. Mahalo.
Thank you. Next testifier. Go ahead.
Aloha mai kakou, Chair Lukes, members of the committee. My name is Kumio Kalama and I'm a staff attorney with the Native Hawaiian Indian Corporation. We represent Namoko, Punio, Kola, Pui, farmers, fishermen, gatherers from East Maui, as well as other individuals from Honolulu. And we're here today in strong opposition to House Bill 2501. And here's why. I think that you may have heard information out there that says that a court case that we filed and that we have an order in would somehow impact all the revocable permits that the board currently has. That's over 300. And that's simply not the case. And right now I'd just like to take a little time to explain why this legislation is really special legislation for the benefit of one company, of A&B and its subsidiaries, and that's it. What's important to understand is the last lease for water in East Maui, coming out of East Maui to A&B, expired in 1986. They began expiring in the 70s. From 1986 to 2002, A&B, HNS, EMI had 1-year revocable permits, 4 of them, that were rotated on an annual basis until 2002. From 2002 until the present, they've been on a holdover status. And that's what this bill is trying to address, this holdover status. Not all the RPs on its list. And I'm not asking you to accept my word for it. What I brought with me today is the words of others that I think you should listen to. The first is Deputy Attorney General Linda Chow before the court. The court asked this question in November. Let me ask this on the behalf of the board. Are there a number of RPs that are on a holdover status, or is this a unique situation? AG says, this is a unique situation that was created because of a contested case that had come in by our clients. So this is a unique situation, she says it herself. Garrett Hugh, who works for EMI, said the same thing. He says, my understanding is that the BLNR put the revocable permits into holdover status pending the conclusion of the contested case hearing. That contested case hearing has been pending since 2001. That's 15 years. We're halfway through what was the application for a 30-year license. A&B's attorney says, in December 2015, the BLNR reaffirmed the holdover status of their 4 revocable permits. Again, this does not apply to all the revocable permits on the list. Lastly, the court's order, you may have seen information out there from the Farm Bureau saying that the court's order invalidates all the permits. That is not true. The order from Judge Nishimura that was issued in January 8th of this year, it says the BLNR authorized A&B's use on a holdover basis that has continued uninterrupted for the last 13 years. That's what she invalidated, that they authorized this holdover status, not permits. The permits that she invalidated expired in 2002. That's very important for you to know. The other revocable permits on the list are on the list because they still exist. They are current permits. They're not expired permits that are held over on this status that comes really not out of the law. It's created. Now, you're being asked to create this legislation in basically an emergency situation. But where's really the emergency? Again, I'm not asking you to rely on me. The County of Maui has already asked the court for a stay of enforcement of its ruling so that it can continue to supply its 35,000 customers in Upcountry, as well as the Kula Ag Park and the diversified agriculture that's occurring there while the appeal is pending. That's going to be several years. Maui County already asked the court to do that, and the court said yes. And what she said was that the county can continue to use that water coming out of the East Maui diversions by A&B to service its customers right now. What she also said is that A&B is not precluded from asking for that same relief. In other words, A&B doesn't need to be here asking you for sweeping legislation that may have unintended, unforeseen consequences that is general and not specific. It gives no time frames. It gives no amounts of water that can be taken. They're asking you to do this when there is an available vehicle right now. They could ask the court for that. And they could explain how much water they need in order for them to continue their operations through the end of 2016, which their own general manager has said is about half of their acreage, about 17,000 acres that they will be harvesting by the end of this year. That's a statement from Rick Vollmer in court, not my words, again. And so why are you being asked to create this special remedy? They're asking you to get involved in litigation that has gone on for 15 years. They're asking you to get involved in something that has 2 open contested case hearings, several open court proceedings, and you're going to come in and interfere with that and create something that, again, you don't know the consequences. Lastly, what I'd like to say is that EMB does have water. They have been pumping, and I have a table, and if you want copies of anything that I've referred to today, I'm happy to do that for you. They've been pumping on average 70 million gallons out of their fields every year. We know that sugar takes about 5,000 gallons per acre per day. That's from their own tables. At half of their acreage, 70 million gallons is pretty close to the amount of water that you would need to irrigate that acreage. And if you don't believe me, ask them. What I've heard is that they're continuing to say they're cultivating 35,000 acres in sugar, while their own statements say that it's really only half. So why aren't they giving back some of that water? If this is an emergency, the court's ruling took place on January 8th of this year. I would ask you, has any water been returned since then? Has any water been restored? Have any diversions been stopped? As far as I know, as far as my clients know that are in the room today, no. So where's the emergency, once again? We should be asking them, why are you running to us to create a solution when you have available remedies and you still have the water? Mahalo.
My name is Lonnie Petrie. I'm from Kapapala Ranch in Ka'u. I'm a fellow rancher with Michelle. This is quite a unique situation. There's actually 5 revocable permits in the district of Ka'u, all from tunnel sources. None of the water is diverted out of streams. We support this bill. If it doesn't pass, I'll just read my testimony. Please consider all revocable permits for water. Passage of this bill is critical. RPS 7054 supplies drinking water to our ranch and all the livestock. Our reservoirs will support delivering water for 4 to 6 months. After that, you're going to see very inhumane treatment of animals. Lactating females who need water first, they're going to die. You can't afford to haul water. After the cows die, then the calves are going to die. You heard Michelle, she can't get her product to market. So these 5 revocable, what's happening is these revocable permits, it's kind of a one-size-fits-all. The water that we deliver from our revocable permit also supports the endangered nene that have made Kapapala their home. The game birds and the wildlife all depend on the water that have been delivered for 96 years. In our case, Makakupu was built in 1920 by the plantation. Ka'u Agribusiness operated the sugar company and the ranch for over 100 years. When my father took over in 1977, that water was almost non-existent because of landslides in the tunnel and aging pipelines. We've invested greatly in 80 miles of pipelines, 10 million gallons of water storage for GL 5374, RP 7637, RP 7758. Kapapala Ranch has tried for years to gain long-term tenure to Makakupu water. We in the agricultural community in Ka'u finally banded together in 2006 and have worked relentlessly for the past 10 years to form the Ka'u Ag Water Cooperative. The purpose of this cooperative was to secure tenure on water sources that would serve the agricultural community in Ka'u. We believed in Act 90 that was passed in 2003. It provided a framework where agricultural leases could have stability in their tenure and equity in their lease. Nothing has come of Act 90 except the investment that we have made believing our leases would transfer the HDOA. Thank you for your time.
Next testifier.
Hello, Chair Luke, members of the committee. I'm Randy Cabral, President of Hawaii Farm Bureau, and I'd like to stand on the written testimony. However, I'd like to address the group from a more personal level. I'm a small rancher in Kau, and I'd like to talk a little bit about the court ruling regarding temporary water permits and how it impacts areas of Pahala on the Big Island. It seems a lot of people think that the ruling only affected HCNS on Maui. That ruling not only impacts HCNS, but all 9 RP permits. Of those permits, 5 are for systems within the Kau area. 2 for Wood Valley, 1 for Olson Trust, and 2 for other ranching operations. These 5 systems provide ag water to farmers, ranchers, and in the Wood Valley case, some domestic water. There is no other source of affordable water should the permits be canceled. The cost of water, hauling water, would be prohibitive. In my case, the loss of water would put me out of business. I have on hand signed petition by about 140 people who live, work, farm in the Pahala area of Kau. They all support HB 2501. Approximately 10 years ago, a group of farmers, ranchers, and landowners, and others, started the process of trying to get long-term permits. We've been working with ADC, Department of Agriculture, and DLNR throughout this time. While some progress has been made, we still don't know if and when the permits will be granted. HB 2501, if passed, will authorize a holdover permit process, allowing permit holders to continue taking water while the long-term permit issue is worked out. I ask that you pass this very important bill. Thank you.
Next testifier.
Hi, Dale Sandlin, Managing Director with Hawaii Cattlemen's Council. First off, thank you for the opportunity to speak today. I'll keep this brief. Obviously, we've heard from both sides of the issue today. We wanted to let all of y'all know that this is not just affecting an A and B versus the tariff farmers. This will affect many other farmers and ranchers across the state. And with that, without the water, they cannot survive, as you've already heard. What this bill will do is to provide DLNR with a mechanism to provide for the continuation of these services until the litigation and or their processes internally have been settled. So Hawaii Cattlemen's Council strongly supports 2501. We ask that you pass this bill, keep it alive, and we appreciate the opportunity again. Thank you.
Aloha Chair Luke, members of the committee. My name is Warren Watanabe. I'm the Executive Director of the Maui County Farm Bureau. We are a county chapter of the Hawaii Farm Bureau, representing 200 farm families and organizations on the island. Our mission seeks to protect and increase the viability of farms and ranches while ensuring the social and environmental well-being of the island. Many of our farmers, ranchers, and Maui residents would be here today if not for their responsibilities back on Maui. Over 500 of them join me via the photos and signatures, and I have copies of this petition. Maui County Farm Bureau strongly supports HB 2501, authorizing holdover permits to be issued to an applicant seeking to renew their water rights lease. While this issue affects other systems, I will focus on Maui at this time. Maui's water infrastructure grew out of sugar plantations. Among the islands, Maui is unique in its dependence on surface water sources. These water systems predated many of our laws. Times have changed since the laws governing water rights were created. The laws were created before contested case hearings, environmental impact statements, not to mention the proliferation of lawsuits that have become commonplace. This matter must be clarified as Hawaii is evolving. The LNR utilized what they thought was the only mechanism they had at that time. Not issuing some kind of legal authority to allow the water to continue to flow was not a viable option. If it needs to be changed, this measure proposes just such a solution. It does not seek to bypass requirements, as it only applies to cases with pre-existing permits. It is also limited only to a holdover period until such time as the pending application for the disposition of such water rights is finally resolved. This means that it is a stopgap measure until the process as identified in the water code can be resolved. This measure merely seeks to address a gap in law. The farmers, ranchers, communities represented by faces and signatures before are depending on you for a solution. For this reason, we respectfully request your support by passing this measure today. Thank you.
Next testify.
Madam Chair, members of the committee, my name is Jim Kelly. I represent Kauai Island Utility Cooperative. We stand in support of this measure. We've submitted testimony. You're hearing today about a lot of wide-ranging potential consequences if the bill is not passed. I think it's important for people to realize, as has been said here, that this doesn't just affect HCNS, this doesn't just affect interests on Maui. In the case of Kauai, we've, for over 100 years, a hydroelectric system that is, again, a legacy plantation system. Kauai Island Utility Cooperative has been using this system since we were formed in 2002. We've had a pending application for a long-term water lease since 2004. This system, which we've invested millions of dollars in, helps us move toward our 100% renewable energy goal that is now part of the state law. It saves the members of our cooperative 500,000 gallons of oil a year that we'd have to import if we weren't using this hydroelectric system. It's really something that we've expected. The revocable permits would continue, and as I've said, we've invested millions of dollars, including a project that's underway right now to upgrade one of the hydroelectric plants. So we really urge you to consider the impact not only on the Maui situation, but on other people, including our members on Kauai as well. Thank you.
Hello, Chair. I'm Mahiolani Wind from Maui, East Maui, and I am a director of Namoko Aupuni Oko Olaupui. Our membership consists of the descendants of the original settlers of the area, Ke'anai, Wailua Nui. These are two adjacent Ahupua'a. And if you visit the area, you'll see that it consists largely of taro lands. There's about 300 to 400 acres of taro lands. I would like to read from my testimony. I opposed Senate Bill 2501 because it would overturn the recent court decision invalidating A&B's holdover permit, a make-believe arrangement with no basis in the law, and allow A&B to continue avoiding laws governing long-term licenses. This is a boutique law especially tailored for A&B. A&B has not complied with legal requirements for long-term leases. With the full cooperation of DLNR, A&B has executed temporary holdover permits for which there exists no authority in the law. These make-believe temporary holdover permits have been routinely and annually renewed for the past 13 years. Judge Nishimura agreed with us that 13 years is not temporary. In fact, the massive diversions over public trust lands have continued unabated since 1925. It is insulting to the intelligence and integrity of this legislature to allow its members to be used this way. This bill would grant A&B a pardon for its illegal acts only made possible because of DLNR's complicity. A&B has been diverting billions of gallons of water over public lands for at least 13 years without completing the environmental assessment ruled necessary by First Circuit Court Judge Hefel. I just want to stop at this point and make a comment, and that is, there was a path to obtaining a permit for Alexander and Baldwin, and they chose not to pursue it. That path was specifically laid out in Judge Eden Hefel's decision in 2003. She said, go do an environmental assessment. Also, this is a long-term permit and it needs to be put out to public auction. Alexander and Baldwin chose not to follow that path. And so it finds itself right now in a dilemma, having allowed 13 years to elapse without doing what the court told it to do. It now asks this legislature to pardon the fact that it didn't do what it was supposed to do. What it has done is that it has been waiting for a parallel action in an agency which is supposed to determine how much water is left in the streams. There was no reason why they had to punt to Cowan. They were told to go do the environmental assessment. In the meantime, for many decades, although our East Maui taro farmers were deprived of water, they followed and put their trust in the law. After 15 years of working through the courts, they finally won a historic court victory last month. But House Bill 2501 seeks to overturn that victory. In effect, it seeks to substitute political power, economic power, and corporate influence for doing the right thing. I can tell you over the many, many years, it's not a surprise to me that those in the room who are supporting these bills are the same people who have been parties to this litigation on opposing side. This is Alexander and Baldwin and all the water diverters, as well as the unions and DLNR. I mean, how do you think the farmers feel? The right thing would have been for ANB to share a reasonable amount of water with the taro farmers when they asked long ago. Instead, ANB intensified and made more efficient and improved the system's efficiency to ensure that every possible job was captured. To use this legislature to sanction the abuse and to overturn a hard-won court battle of 15 years is a slap in the face to our law-abiding community, many of whom are decorated veterans who served this country in combat, including my husband, who's going to be speaking after me. It is a misappropriation of precious trust resources and a betrayal of the public's trust. Of the billions of gallons diverted from public lands, less than 10% is sold to the county of Maui for public upcountry and ag park consumption. The remaining 90% is used for ANB's commercial sugar, a crop which requires more water per acre than most. Now that HCNS is shutting down its sugar operations and transitioning to diversified agriculture, surely the taro farmers who have priority of pertinent water rights and who are also agriculturalists in the purest sense deserve fairer treatment. Please don't make an ill-advised practice that was illegal legal. There is ample water for all parties to share. Do not pass a law that would legally sanction ANB's attempts to skirt environmental laws and continue to deprive taro farmers of their constitutional rights. And I just want to say one more thing. Representative Linda Coit was in our area last night. The room was packed. All of the constituents there were from East Maui, from Kaupo all the way around the island to our moku, which is Ko'olau Moku, Hamakualoa, all the way to Huelo, out to Maliko. They were all represented in that room, and they told her with one voice to stop this bill. Thank you.
Aloha. My name is Edward Wendt. I have been president for Namoku Aupuni o Ko'olahui since the 90s. In 93, we had the first water conference, and we had the Attorney General's office attend this meeting with our lawyers. 1 week later, this man was fired from his position. In 1977, I was the Taro Farmer of the Year. I'm also a combat veteran. Many more that followed this case are veterans. Even my son, who's a commanding officer today, cannot believe what we are going through. In these years of litigation, I've seen and experienced 7 to 8 other men or women that from the state of Hawaii was removed from their positions because they wanted to do good. For these ranchers, I support ranching. My son works on a ranch. I support farming. What kills us as veterans who fought for your rights, your constitutional rights and mine, this bill is a slap in our face. As veterans, this is called genocide. At the end of the trail, this bill will supersede the existing laws that was created by the state many years ago. Your kuleana is to uphold the law, not to tear it apart. As a veteran, if I conducted myself like you or others, I'll be put in jail. This has been a struggle. When I became a terraformer in 1977, there were water. But after that, as she testified, they were taking and taking and taking until they dried us out completely. I hear farmers, 100 years. I'm a sixth generation to this Aina farm. The same rivers, the same stream, even the same loy. This is an insult. As a member of Namoku and the president of Namoku, Aupunik Okoholahui, we oppose this bill. This will have great repercussion of the mismanagement of DLNR and BLNR. There are many more, and we're just sitting on the fence, waiting for your decision. Mahalo for allowing me to speak. Thank you.
I have one more thing. There's one and only one holdover permittee who is diverting water, and that is Alexander and Baldwin. The name of this bill, it's described as pertaining to water rights. Alexander and Baldwin is the sole holdover permittee. So it is tailored for Alexander and Baldwin. Furthermore, with respect to the ranches who have just testified, they have legitimate revocable permits. That is not what is at issue here. What is at issue is specifically the abuses that have occurred, which is so-called holdover status, which is supposed to be temporary but has been going on indefinitely, and as Judge Nishimura said, by their reasoning, could go on in perpetuity forever without any accountability. Thank you very much.
Thank you. Next set of testifiers, please come up.
Mike Kaku, Chair Luke, members of the Finance Committee, East Maui Rep. My name is Shelly Munioka, and I'm here to testify today on behalf of Kahea, the Hawaiian Environmental Alliance, as a board member. And we represent over 10,000 supporters in strong opposition to HB 2501. Water diversions, I submitted written testimony, but I would like to supplement that with another statement. Water diversions to the streams in East Maui began in 1878 by some of the same people who 15 years later would orchestrate the overthrow of the Queen. Since then, A&B has diverted literally billions of gallons of water from East Maui, whittling down kalo farming from several hundred acres in cultivation to just 20 acres by the 1980s. In 1987, the state of Hawaii adopts the Water Code, and in it declares that the waters of the state are held for the benefit of the citizens of the state. So citizens, not corporations. It is declared that the people of the state are beneficiaries and have a right to have the waters protected for their use. To be clear, corporate interests do not have constitutionally protected rights. And looking a little bit deeper into the Water Code, we'll find some language that's relevant to today's issue. It says, to obtain a permit, the applicant shall establish that the proposed use of water will not interfere with any existing legal use. In this case, the existing legal use of water is the irrigation of lo'ikalo in East Maui, which are protected as traditional customary practices under Section 12 of the state constitution. This practice long pre-existed the diversions. It goes on to say in Part 6 of the State Water Code that the Water Commission shall protect stream channels from alteration, which is diversions, whenever practicable, to provide for fishery, wildlife, recreation, aesthetic, scenic, and other beneficial in-stream uses. In-stream uses are defined earlier in the document as beneficial uses of stream water for significant purposes which are located in the stream and which are achieved by leaving the water in the stream. In-stream uses include, but are not limited to, maintenance of fish and wildlife habitats, outdoor recreational activities, maintenance of ecosystems such as estuaries, wetland, and stream vegetation, waterfalls, the aesthetic values of waterfalls, and lastly, but not leastly, the protection of traditional and customary Hawaiian rights. I have compassion for the ranchers and farmers who currently rely on this water, but their uses are not constitutionally protected. It is not their fault that they built their businesses on top of an inequitable, genocidal system, but it is not right nor legal to ask the East Maui community to give up generations of traditional practices, observations, and ike in this area. And this is not just about past practices, but this is about the extermination of future practices and a real chance to subsist and self-sustain. When the state adopted the Water Code in 1987, it was taking a step forward in codifying laws to protect one of our most precious resources. However, A and B did not take that same step forward, nor did the state compel them to do so. Instead, they continued the bad and now clearly illegal practice of diverting water to the point of injury in downstream users. The laws that protect kalo farmers in East Maui are completely clear. They have received many favorable rulings in administrative and legal avenues. But at every turn, they have been forced to sue to have those rulings enforced. And in the interim, years roll by, the streams stay dry, and life dwindles in East Maui. After their last 25-year lease expired in 1986, A and B was operating under temporary revocable permits. It wasn't until 2002 when DLNR once again issued these permits, this time on a holdover basis, that this really came into the issue that we're looking at now. A and B are the only users that have that special holdover status. And this is key because the reason that these temporary revocable permits do not require environmental review is because they are intended to be for short-term uses. The holdover status that this bill seeks to make permanent runs counter to that intent. As previous testifier Auntie Mahealani Went testified, A and B did have a path to that lease. And that lease was issued by DLNR in 2003, which the community successfully challenged in court when Judge Chifo said that they must first require an environmental impact statement. To date, A and B still has not completed that EIS, and their failure to do so keeps that lease in a legal limbo, which they're now trying to use as justification for this holdover status. Earlier this year, Judge Nishimura ruled that the state law does not authorize DLNR to hold over A and B's revocable permits for more than 13 years because that does not meet the common sense definition of temporary. These temporary permits, because they're supposed to be for short-term uses, do not require environmental assessment, but nor do they go out for a public bid like a regular lease would. A and B has used this holdover status to sidestep laws in place to protect special places, resources, and the people who depend on them. And HB 2501 is a clear attempt to extend this bad practice. For Hawaiians, water is literally life. It's not a metaphor for life, it's actual life. There's enough water for what people need on Maui. There's enough to feed, but there's not enough for the greed of this one company. We please ask you to reject HB 2501. Mahalo.
Aloha, I'm Margie Thompson. I'm the director for the Sierra Club of Hawaii. We stand in opposition to House Bill 2501. Thank you very much, Representative Luke, Vice Chair Nishimoto, and members of the committee for this opportunity to testify. I think as you can see here, this is an extremely controversial bill, and I have a few handouts to help further demonstrate that. First, I'd like to turn into the committee a petition in opposition to House Bill 2501 signed by 4,165 people. Did you pass that? And you've heard from the testimony today that there are people on all sides of this issue. I don't think the legislature is in a position to be making decisions about who has access to what water. That is the reason the legislature formed the Water Commission to serve that role. By considering this bill, the legislature is stepping into a highly litigated, polarized, and localized conflict, one that requires considerable command of the science, history, and law to make an informed decision. The Water Commission is the appropriate body to be making that decision, not this legislature. After years of intransigence, the system the legislature created is finally and fully engaged in decision-making about A&B's long-standing harmful diversions in East Maui. The Water Commission is preparing its rule in the contested case, on minimum entry flow standards, and the circuit court decision on A&B's holdover permits is being appealed through the judicial process. I want to be clear that the Sierra Club is not opposed to legitimate agricultural uses, activities using public water. We all want to see agriculture continue on Maui and on all islands. But the information you're presenting here today, I think, is insufficient for you to make an informed decision about this bill. There's way too much going on. It's just one line in the statute you're adding, but man, look at what we've unraveled. So I have a few recommendations, and before you make a decision, I would suggest that this committee seek a formal opinion from the Attorney General's office about the applicability of Judge Ishimura's decision on A&B's holdover permits, as well as the applicability of this proposed bill. Does it indeed affect anyone other than A&B? In addition, I would suggest asking A&B's representatives if they have filed for an appeal in Judge Ishimura's decision, and if they filed for a stay, requesting Judge Ishimura to stay the enforcement of her decision. If they haven't, why not? In addition, I think it's important for this committee to know before they decide what is A&B's intended use for this water that they seek to divert. If sugar is closing, why then do they need to divert this water? I've spoken with all of you, most of you, so you know my position on this bill, our organization's position on this bill, and I think you've heard from our many, many members. There is a lot of concern and contention about this bill. I think that if this committee is not interested in pursuing these recommendations any further, asking A&B to answer some questions, getting a formal opinion from the AG's office, then the best way to strike the proper balance in this very controversial circumstance is probably for this legislature to not act at all. Allow the legal process to run its course. Create the conditions that require A&B to rely first on its own resources before taking from others. The system that we have in place right now provides ample opportunity for this corporation to assert a legitimate agricultural use and request adequate water resources from the public inventory. I've said this to all of you, there definitely is more than enough water on Maui for everyone to thrive. There is no reason for anyone to be going without water. There is more water running in the streams of East Maui, or should be running in the streams of East Maui, than the island of Oahu consumes every day. No one should be going without water. All we need to do is manage it better. Thank you.
Thank you, Mr. Supplier.
Hello, Chair, Vice Chair, members of the committee. Sterling Wong, Public Policy Manager for the Office of Foreign Affairs. OHA opposes HB 2501. We understand that there are concerns regarding the needs for water to continue agriculture in Central Maui and to fulfill A&B's obligation to provide upcountry with water. We share these concerns. However, we believe that A&B has a number of alternatives to meet their water needs. In light of this, we urge the committee to hold this bill and not make our taro farmers in East Maui continue to wait for water. Mahalo.
Thank you. Next.
Aloha, my name is Kayleen Kawila Sheldon. I represent the John Mon Kaikina Kelekona Foundation, and which is an organization that protects sacred sites and Hawaii's natural resources. I'm in oppose of the bill. I think that this bill is become unclear, and it is also, and it reads on the bottom that holdover permit to be used to an applicant seeking to renew their water rights. And I'm just wondering who are actually the applicants. I know that there were some ranchers here, and I feel for them as well, but a lot of taro farmers, such as my family in Keanai, they use this water for their lo'i kalo, and these lo'i kalo been thriving since before any of us was born, before I was born, before any of you were born. And when you look at the last names of some of you, your names are on the Great Mahele, I believe, in the 1800s, that were responsible for these water decisions and were responsible to Malama of the natural resources. So I hope that you oppose this bill. I also hope that these large corporations, that they learn from us, because hoarding water for their hotels, golf courses, and new homes, and forgetting about the kalo farmers and people that grow food is very detrimental to the sustainability of Hawaii and for the people that already lived here for thousands and thousands of years who thrive, and also the residents of Hawaii as well. Our natural resources have been depleted and hoarded since the fall of our Hawaiian kingdom. We need to restore and preserve our natural resources for generations to come, and I hope that some of you fulfill your kuleana from your ancestors and follow their traditions. And malama Hawaii. Mahalo.
Thank you.
Good afternoon, Chair and members of the committee. My name is Leimana Damate, and I am representing the Ahamoku that is attached to the state through DLNR. This is a very, very hard bill to work with. We oppose the bill because I wanted to bring another perspective to you, and that is the perspective of the Native Hawaiians. You heard Mahealani speak earlier of a meeting that was held last night where every moku was there. What you should know is that of the 6 or 7 moku for that whole East Maui, there are over 77 ahupua'a connected in those moku. Can you imagine how many Native Hawaiian mahi'ai and farmers, and even going down to the shoreline, because the fresh water impacts the nearshore fisheries all along that coastline as well. They have truly, truly suffered. What's so difficult about this bill is that it is geared only towards one landowner, one company, Alexander and Baldwin. Now, personally, I have to tell you that all the testimonies that we've heard so far are very painful. More painful for me because I live in Ka'u. And to hear our own people from Ka'u, our ranchers, people I know, talking about revocable permits, and I know that their companies are going to suffer. Their ranchers are going to suffer. They're caught in a no man's situation because the process was not followed. So how do you go about protecting the people of Maui who need to be protected, and still protecting the people on the other islands, ranchers and farmers who are caught in the same trap? Do you see how painful this can be? We are putting our trust right now in this body to do the right thing, and also into DLNR, to whom Ahamoku is attached, because they have taken the position of forming a task force to look into this issue and this problem. They understand the hurt. It's not only Ka'u and Hawaii Island and Maui, especially Maui, who's going through this. It's every single island that has been caught in this process. I ask you to oppose the bill because no one owns the water. If anyone has any kind of claim on the waters of the public trust, it's the Native Hawaiians, because their idea of ownership is stewardship. Nobody owns the water. It's supposed to protect the land. Thank you for this opportunity.
Thank you. Next testifier.
Hello, Mike Alco, Chairwoman Luke, members of the Finance Committee. My name is Joshua Nonga from the Ahupua of Hau'ula, Moko of Ko'olau Loa on the island of Oahu. I come here to oppose House Bill 2501, ask you to restore the water to the streams of East Maui. I sent in testimony, but I would like to just point out a story, a small story that from my testimony. My great-great-grandparents settled in Honolulu and Damien Tract right at the turn of the 19th century, early 1901. They were pushed off their aina in the sugar plantation, came through much like Kanaka at the time, who were forced out because the waters were diverted. The water was diverted from their streams, and the streams no longer flowed into their lo'i. They were no longer able to feed themselves. Not being able to feed themselves, they had to provide a way to provide for their families. Being unable to feed themselves and live a sustainable lifestyle, they were forced into a market or an economy type lifestyle. So my grandfather, my great-great-grandfather, Samuel Valentine Kaulia, settled in Damien Tract, where the airport is now, big Hawaiian tenement. So there are thousands of Kanaka Maoli from all across the islands that came to settle in this area of Damien Tract. He became a wagoneer in the United States Army during World War I. It took many years. My great-grandfather and then my grandmother was born in the 1920s, settled in Damien Tract. It took a long time for my family personally to escape the trappings of urban Honolulu. Yeah, I grew up in Kalihi, in the housing, so I still, from my grandparents, and from that time, still very much a product of the flow away from our lo'is and into the urban Honolulu. And being raised in Kalihi, in urban Honolulu, I always knew that this isn't exactly as Kanaka where I'm supposed to be. You know, I'm not supposed to be living in concrete jungles. I'm not supposed to be, you know, a lot of these elements. I'm supposed to be playing in the streams. I'm supposed to be playing in the lo'i. I'm supposed to have this access. I say this story because I have a lot of friends in East Maui, and I wanted to come out here to show support because they weren't able to fly over here. Earlier I came to pick up Auntie Lucienne, who she came in from Maui as well. I live out in Hau'ula where we raise our kids. We're trying to start a community lo'i out there, and water is very important for us. The very reason why we're trying to, for me, to put my children back in the lo'i is to correct the wrongs that happened over 100 years ago. Like, we can't do really anything to go back, for me, and change our family's history of this flow to urban Honolulu. We can't do anything of being directed off of our aina. But what we can do is make sure that our children have that access. Now, why I'm afraid of this is there aren't many of Kanaka who have continued to, throughout the change of Hawaii, been able to stay on their aina, regardless of this, the change of the overthrow, the commercialization, urbanization of Hawaii. And throughout that, here on Oahu, many of us forget, but there are those on Maui, on Molokai, on the Big Island, on Kauai, that they can hold on to. And I would really like for us to support these East Maui farmers who, you know, by tooth and nail are hanging on to this. You know, I see this, their court case victory that they had as a tremendous step in the right direction. I would ask for you guys to follow the advice of Ms. Townsend to check with the Attorney General in regards to the legalities of this, stepping outside, using the legislature to, in a sense, overturn a court ruling. But most of all, just think about this story and think about what this possible repercussions could be to those of East Maui if these waters aren't restored. How many of those families may have to come to Honolulu? How many of those families may have to find work or either provide for their families in other ways because of these waters haven't been restored? So I want to mahalo you guys for your guys' time. Aloha.
Good afternoon, Chair Luke. Dave Arca on behalf of the Land Use Research Foundation, and we strongly support House Bill 2501, House Draft 1, to allow holdover disposition of water rights previously authorized pursuant to a lease during the pendency of an application for lease renewal. The Land Use Research Foundation includes as its members A&B and a number of other large landowners who have designated over 50,000 acres and voluntarily as important ag lands on a number of the islands. And so water is very, very important to the important ag lands uses of the LERF members. We'd also note it's our understanding that the Circuit Court ruling leaves a number of permittees which have had revocable water permits in place for longer than 1 year in limbo. And we understand that the ruling could negatively impact Kauai Island Utility Cooperative, Hawaiian Electric Light Company, and several other entities, individuals, and small farmers which hold state annual revocable water permits. On the island of Maui, we understand that the majority of the water is used for domestic and agricultural purposes in central and upcountry Maui, and would not be available until a long-term state water lease is secured under the court's ruling, which may be years away. This vital water source has enabled agriculture to thrive in central Maui for over 100 years and is essential to keep these lands in continued agricultural production. And we have to repeat again, important agricultural lands. Without water, water was one of the main qualifying criteria to get those lands designated as IAL. If people want to punish A&B and others and take away the water, then those lands are not going to be qualified for important ag lands anymore. We'll finish up, Madam Chair, and we'd ask that this committee take appropriate action to address the problem that's suffered by a number of permittees, not only one permittee, and pass this bill and allow the Board of Land and Natural Resources to take a narrow exception and allow for a holdover disposition of water rights previously authorized pursuant to a lease during the pendency of that lease renewal process. In closing, the Land Use Research Foundation doesn't usually agree with the Sierra Club, but in this case we do. And when the Sierra Club said, there's enough water on Maui for everyone. And so agriculture, we believe, is important to Maui, so we ask that you please approve this bill so that important ag lands can continue to be farmed on Maui. Thank you.
Hello, Chair, Vice Chair, members of this respected committee. Keikoa Kaluhiwa, First Deputy Director for DLNR. My testimony today is very brief. We are, for the record, just wanting to stand on our testimony with no objection to this measure. We have our written testimony. I would like to just mention, as you had heard, this is currently under litigation, so I'm somewhat limited in the information that I can provide. But I also want to just acknowledge the issuance of revocable permits, whether it's for land or water, is very important to us. As you've seen in the media recently, we have since created a task force to look at how we issue revocable permits. Following this round of testimony, if you have any follow-up questions, I'm here, as well as our Water Deputy Chef Pearson and Kevin Moore from our Land Division to take any questions from you. Thank you.
Thank you, Chair. Luke, Vice Chair Nishimoto, members of the committee. My name is Meredith Chin, representing A&B. You have our written testimony, but I would like to respond to some of the points that have been raised today. As has been said, this bill does not only affect A&B. There are a number of other water permit holders who have been on longer tenures than 1 year who will be affected. Utilities on Kauai, utilities on the Big Island. And it isn't only something that applies retrospectively. This is a tool that the Board of Land and Natural can use moving forward. Having said that, this bill does apply only in very limited circumstances. When somebody had a previously authorized water permit, like a lease or a permit, and has applied for another long-term lease or water disposition and is waiting in the interim. We think this is appropriate in today's world because the lease process can be quite lengthy, involving environmental review documents, contested case hearings, appraisals, in-stream flow standards. These are processes that are supposed to lead us to better resource decisions, not to lead to no use of resources, which would be the default if this bill was not passed and the current circuit court decision stands. I also want to clarify, there's been a lot of talk about who should get the water, who is a proper user of the water, and this is not about amounts of water. That's what the IIFS, in-stream flow standard, will determine. This is a binary decision. Either state waters from East Maui and other places can be allowed to be collected under a permit, or they can't. And so right now, the BLNR only has two tools, a one-year permit and a long-term lease. And there's just this big gap in the middle. Some have questioned why we didn't just let this play out in court rather than seeking this legislative relief. We believe that there's just too much risk to follow that course of action. But to answer the Sierra Club's question, yes, we did join the county's request for an appeal, which was also joined by the state. So we have filed for appeal. As for the stay, that's not a solution. It's only temporary. It lasts until the appeal is decided upon. And if the higher court confirms the circuit court's decision, as I assume is their desire, then what happens to the 36,000 upcountry Maui residents and the 36,000 acres of agriculture on Maui? Water just stops flowing to them as soon as that court decision is issued. So in her decision, the circuit court judge specifically questioned legislative intent as the basis for her ruling in validating state permits with terms longer than a year. So we think that this is an opportunity, an invitation to the legislature to clarify its intent under HRS 171. I do want to point out that in this situation where the East Maui lease, an EIS will be performed, the inter-region flow standards will be completed, and the lease will be put out to public auction for anyone to bid on. None of these processes or requirements are changed by this bill. Maui's on the cusp of a transition. After more than 145 years, sugar will not be grown across the central plain of Maui. It won't be grown anywhere in the state anymore. And water needs are going to change. So many people have asked us what our plan is for diversified agriculture. And while we don't have a firm roadmap, we do have a vision. Our end vision is a patchwork of compatible agricultural activities blanketing central Maui, some farmed by us, some by others. We see biofuel crops that could provide electricity or transportation fuel to support the state's renewable energy goals. We see irrigated pastures for local ranchers, so their cattle don't have to be sent to the mainland anymore for grazing. We see food crops. We see evaluation of crops new to Hawaii, such as the much talked about industrial hemp. And we see an agricultural park open to community farmers. While we can't say for certainty when our vision will be complete, we are determined to explore a number of different paths and assess their viability in a disciplined manner. So it is highly unlikely the A&B will ever use as much water as it had in the past with sugar. The only scenario for using the same amount of water as sugar is if biofuels hit it big and was across the 36,000 acres of Maui. In our early stages of diversified ag operations, as new crops are in their trial stages, our water needs will be significantly less. And during this time, we will divert only the water we need, with the rest remaining in the watershed for other uses. But as our trial ag projects prove viable, as we hope, and we expand our agricultural activity, our water uses will increase, but less than we consume today. So if there is to be any chance of an agricultural future for Central Maui, it is essential that access to state waters in East Maui be continued, particularly during these initial transitional years. Thank you for this opportunity to testify.
Thank you. Next testifier.
Hello, Michael Ako. My name is Nano Reyes, from the island of Oahu. I'm a farmer in the back of Kalihi Valley. I'm a third-generation farmer, third-generation fisherman. My dad and my grandfather are from the island of Molokai. And they taught me how to fish. They taught me to know my footprint of everything that I do. So I know my footprint of how I farm. I know my footprint of how I fish, and I think that I do it pono. I'd consider myself a steward of this land, and a steward of our ocean, a steward of our islands. I know that water in our streams means breeding grounds for mullet, means breeding grounds for a whole bunch of other fish, means breeding grounds for hihiwai, opai, all that kind of resources, that if there's no water in the streams, if the streams are not cold enough, that we don't have that we don't have those breeding grounds. My question to you guys, I'm not allowed to ask questions, but is how many people actually grow food here? How many people know about our resources? How many people study or lived our resources in Hawaii? And I'm guessing not too many people. And we can go around the whole room and we can say that, but I can say that I do. And so for the fact that we're making this decision in this room, I think there's a problem with it, right? Don't you? I don't go to a restaurant and tell a chef how to cook. And it's the same thing, that if we don't understand our resources, if we're doing it for the sole purpose of making money for a big corporation or for this plan of diversified agriculture, then why are we really here? Then just give it to them already, right? And we've seen in the past that when we put our resources, when we put our natural resources second to big corporations or to decisions that are made inside of a cement building, that the resources end up losing. And in the end, who really loses? Everybody here, right? We see aquifers crash. We see all different kinds of drinking waters disappear. We see food systems just completely disappear. And so to look at that, we can talk about resource management. And so who's managing our resources? We talk about DLNR, Department of Land and Natural Resources. And if they're going to stand behind this, then I have a problem with them. And I'm sure a whole bunch of people sitting behind or sitting outside have a problem with that. That if we're Department of Land and Natural Resources, why aren't we standing against this? That there's resources that are going to die, that we're going to lose resources because of this bill. And if we're going to sit here and say that we support it, then everybody in this room should question Department of Land and Natural Resources, because that turns them into the desecrators of land and natural resources. We look at A and B's history. We look at all that agriculture, they call it agriculture, that was done on Maui. Is it really agriculture? The culture of ag, right? The culture of growing food, the culture of growing plants. Have they? Have they really? Let's look at the land that they've used. They've done nothing but desecrate it and ruin it, right? They've grown one crop. I think the most diverse that they've got is the amount of chemical pesticides and herbicides that they use on that land. And so we want to talk about that. I say I do a little bit of diversified agriculture in the back of Kalihi Valley. We have a lot of rain, but we don't have flowing springs. We have stream water, but we're not allowed to touch the stream water. And so we grow the food that we can with the water that we can and the land that we can. We don't pipe in water, and we don't use city and county water to water our crops. We grow what we can with the resources we have. And we understand that, and we understand our footprint again. Today I was talking with one of my uncles, and he's actually a sheriff at one of the boys' homes in Ko'olau. And he talked about a kid who said, I don't have trust issues, I've seen this crap before issues. And so for A and B, I don't have trust issues with them. I already seen what they've done. I already seen what giant corporations have done. Dole, Del Monte, Monsanto, everything. I've seen what they've done. They come in and they make this, they paint this pretty picture. And then when it's time for them to leave, they hide behind the rest of the community that upcountry Maui is not going to have any water, and everybody knows that's not true. If we're going to, they can't stand alone and say that they're not hiding behind. I'm not here for the farmers on Maui. I'm not here for the kalo farmers that don't have any water. Yes, I feel for them. But I'm here for the resources. I'm not here for A and B. I'm not here for any side. I'm here for the resources, yeah? So I hope you guys take that into consideration. Mahalo.
Aloha, o wau ka puakili I kua ka mai. No ka aina ho o pula pula, ka awawa, wai anai, mai au. He maka aina nā au. Ole au I kanaka mahi ai. Ole au. Ole ike au ko u ina mea Hawaii. You know, I think many of us in this room, like brother was just saying, how many of us are actually growing food? How many of us are producing food? Not me. I'm learning things. I'm trying to apply things, but I don't know them. But when I look to my ancestors,
to our kupuna, who knew things that we call it, traditional wisdom. But what it is it's the connection of the Kanaka to the Aina, of the Kanaka to the Akua. It's that bond that Native people have, not the American Native definition, but Aboriginal people have with their land, with their fresh water, with their salt water, with their mountain, with their resources, and the respect that our people have for these resources. Our ways have been, take what you need, but when you take, replace, because after you, there will come others. That's how our kupuna was able to provide for the people of time past. That's their genius, is that it wasn't about me here now. It's about them to come, the generations to come. Them, not me, not mine. That was not our mindset. That is not our way. That's how our people did it. So when our people received these newcomers, they didn't know any better. They knew not what they were doing. And by the time some of them caught up to it, it was too late. So even some of you, you knew not of the decisions that you made in the past, how it would adversely affect you and yours today and tomorrow to come. But when you contemplate that, how many of us regret those decisions that has those, what do they call it, unforeseeable impact, the negative impact? So we have to go beyond this person, this corporation, for what they have done, what they want to continue to do. You folks know all the facts. You really know the facts. You have it. So I appreciate that you let us, especially a Maka'ainana person, a regular person, to come and speak to you. But it's for the generations to come. So let it not be for the one or for the few to monopolize the resources, to hoard the resources. Let that not be our way. Why isn't our way a merkako? That's how we're gonna allow our children to continue to live in this beautiful place that some of you choose. This is the home of my people. This is my home. This is going to be my baby's home. I am also Portuguese, but this is our home, and this is where I want all of my descendants to be, if they choose to continue to make it here. But with some of the corporations and the way that government is going, very difficult for our children, our descendants, to stay here. But you have the choice. You have that power and that control. And to say, how are we going to provide for them to come. These tough decisions that you folks have, you have the facts. You really have the facts. And I'm not trying to just do this on an emotional, but this is more of a moral. Morally. Where is your compass? Mahalo.
Thank you. Next testify.
Hello, my kako. Pe yauko. Hauli. Puiva. Makau. Kaumaha. O kako hukalani, wahilani. Maya. Wayanaya me puea. Maya. Come before you to oppose this bill to Ku'e. And plenty that came for, but everybody forget, before A and B went divert the water. I'm looking at you guys. For A and B went divert. 23 streams running 365 days a year up East Maui. Now, Aohe, Kawai. Like Noah said earlier, who grow their food over here? Raise your hand. Who grow your food? Maikai. Kan. Napiai, aloha aina. I come from Puea, Waianae Valley. We had 7 streams up there rolling. Now only get 2 because of mismanagement. Everybody forget, the lease supposed to be up A and B. I heard somebody, I think that Chang person was talking about the future. Well, they had over 100 years in the past and the present. What about the tenement rights of the Lo'i, the Kalo farmers that was there? They're still waiting patient. Generations of Kanaka. Not only Kanaka, Napo'i Hawaii. You know what is that? Kanaka is Kanapo'i of Koko. Napo'i is people of the island. They're also waiting for them. They're also waiting. And to me, I think of all the water that is being diverted one day from East Maui is more than the consumption of the water on this island, and we get what, almost 1 million people on this island? That's crazy. So please, you folks kuliana, kakote, for do what is pono. Not for big business, for the people, because the people can still be here. Will still be here. So, vehi kapu uvai. Open your hearts. Ho'olohe, nakupuna. Listen to your ancestors, wherever you folks may come from. I stand for our kupuna from the past, for our nakeki, for the future. Just do what is right. Please. Alexander Baldwin, they had over 100 years. When is enough? Is enough. When is enough is enough. We let Uncle went them over there. Come on, people. We gotta think sustainability. You guys went to the streams in East Maui? The 23 streams that all dried up? Have you guys went there? Oh hey, ola. No more life. Kawai ola. Water is life. So my po'ina, never forget your judicial duties to take care of what is pono for the people. Not just special interests, not for people that was here 100 years ago. My po'ina, people that was here 1,000 years ago, and we still here. So my kalamayaw, my demeanor, but kaumaha ya'u. Nui Kalmahayau. Very deeply sad. So my Pulina Yauku, don't forget. Nanaike Kumu, look to the source. Nakupuna, our ancestors. Not only mine as on Kanapoiwi, but everybody inside here, your ancestors, where you came from. It was my Kai. Don't forget that. So, please, Olohe, Vehekapu Vai, open your hearts.
Okay, thank you. Next testifier, please.
Hello, my name is Kupono Meleane Kikuo, and I'm opposed to this bill as well. And the reason why I'm opposed to this is because of the natural resources from all the water that goes down the streams. And from you guys diverting the water, it doesn't cultivate the limu in the on the streams that feed the little fish that the big fishes from the ocean eat. And they're saying a lot of the fish is like low amounts of fish because overfishing, but it's actually because everybody's diverting all the rivers and it's not feeding the bigger fish, so it's kind of like they're starving as much, you know. And that is the reason why, the natural resources that feed our people, and that's why I'm opposed to this bill. Thank you.
Thank you.
Good afternoon. My name is Alan Murakami. I'm the Director of Community Engagement with the Native Hawaiian Legal Corporation. In my past life with the corporation, I was one of the attorneys that represented East Maui farmers, cultural practitioners, trying to preserve their lifestyle in the spirit of the state constitution, which guarantees those rights to protect cultural traditions of Hawaiians. And I say that specifically because I hear echoing in this room the voices of people that have long experienced what the impacts of this massive diversion has been. And I say massive not without cause, because it is probably the single most massive private diversion in the United States. You already heard comparison about how much water this diversion takes in relation to how much water this island consumes. That is an incredible amount of water for one entity, one company. And I want to say that in addition to the presentation by my colleague Camille Kalama earlier, which really laid out very well the current modern day context of this bill and the issues that it presents, I want to go back a little bit, because these witnesses that testified, especially the Hawaiian ones, really resonate what was being said back in the late 1800s when the first sections of ditches were being constructed. There were protests coming from East Maui not to allow Klaus Spreckle to take that water out of East Maui, because they feared that those diversions would hurt the downstream owners who were farming, gathering from the streams, and fishing in the oceans that are fed by those streams and create essential ecosystems, brackish ecosystems in estuaries that are vital to the complete life cycle of fish and other marine life. They were freaked out. As a result of those protests, the royal government imposed conditions on those initial leases that no downstream owner should be hurt. That language continued for the next 140 years. In every disposition issued by the kingdom, probably the republic, the territory for sure, and now the state of Hawaii. You can find them in the revocable permits today. And there's a reason for that. It's because generations of Hawaiians have continued those traditions, largely invisible, frankly, to many of the larger population who don't go to East Maui, who don't see what's happening in those lo'i day in, day out, and in the streams and the coastal areas where the fishing and the gathering occurs in the spirit and tradition of the ancient Hawaiians. A tradition that is enshrined in our Constitution to protect as a matter of state policy, Article 12, Section 6. Okay? So it's this backdrop. from which I am proceeding with this testimony, because it is so crucial to understanding why this bill is so ill-advised. Okay? In 1905, Alexander and Baldwin, the same one you see here today in its earlier form, sued Wailuku Sugar Company. Why? Because it owned Kuleana, which had water rights attached to it that were tied to the prior use of water to grow taro downstream of Wailuku Sugar in central Maui. They won. They won on the basis of a law that respects the cultural traditions of Hawaiians to grow taro and to have the absolute right of water to grow that taro. They won. They used that principle to their advantage so that they could get water to their lands. In essence, that's the very principle and holding that we have been applying in this generation to stop A&B from impacting the taro farmers, the traditional gatherers and fishers that are downstream. So we had that law, we had the conditions in the permits and the leases throughout this 140, 50-year period to protect these farmers, but it has been, frankly, a grudging acceptance of these conditions from state government. I've told our clients, Edwin in particular, we should have won this case 10 years ago easily. The law is that clear, and it was made even more clear by the litigation of Alexander and Baldwin litigating in 1905 on the very principle that we are seeking to enforce today. Okay? And it has found itself not only in our state constitution, Article 12, Section 7, but in other provisions protecting water resources that has led to our Water Code and the Water Commission. It has also been found in the mandate for cultural impact assessments in preparing any environmental assessment or environmental impact statement passed in the early 70s. These are requirements that have been interwoven into our system of laws very carefully to respect these traditions and the laws that evolve from them. Okay? So what happens now? Flash forward to 1986, the last of 4 25-year water licenses issued to A&B previously expires. But because of litigation around the Robinson-McBride case going on at the time, the state chose to get into revocable permits that are renewed annually, not long-term dispositions. Okay. Finally, in 2001, they come forward with a proposal to issue a 30-year license or lease to sanction this water use. And that is the case which we appealed, resulting in the Judge Hifo decision you've heard about, that basically said, hey, wait a minute. First, you cannot issue this lease as you have without first requiring an EA and probably an EIS because of the massive impacts this diversion will have. Okay? Very clear law on that point, and it was reinforced several years later in the Super Ferry case, which held the same thing. Super Ferry could not continue without a preliminary EA conducted before the permission was given for Super Ferry to operate. And there's a very good reason for that. The idea was to give decision makers this information about cultural impacts before any commitment of state resources is made, in this case water. Now what clearer impact could there be than to take water away from farmers, fishermen, and gatherers, from water that has been diverted off of, guess what, 33,000 acres of Crown lands. Crown lands are the best lands that the former kingdom lost without any compensation under the act of war, words of the U.S. Congress, not mine, that accompanied the overthrow. So you now have water being taken off of lands that were in essence stolen in the eyes of many Hawaiians to deprive current Hawaiians of their own livelihood. I mean, it is like compounding injury upon injury, scar upon scar, insult upon insult. And you've got to understand this because that's how these communities see this situation and how this bill has to be cast. Another notch in that belt that A&B has been able to wear in order to continue this diversion for over a century under one rationale or another. okay? And so, while we litigate this and come up with this result, basically, applying the laws that were won by A&B 30 years ago, that downstream owners who grow taro have a superior right to water. The cultural impact assessments that were incorporated into the EIS law that require advance information before you make major decisions of this sort. The constitutional protections for the traditions and customs that are enshrined in our very Constitution in 1978, and other provisions that protect water resources as a public trust that led eventually to our water code. All of these laws evolving over this century plus, all designed to protect these cultural traditions, all designed to protect water for those cultural traditions that are so vital to them. And what do we have? And a ruling in 2003 by Judge Hefel that basically says, I'm going to respect this law. You can't issue this release before you do the EA and probably the EIS. And by the way, that EA-EIS is not limited to just what impacts occur as you continue the diversion on the last day of any permit or lease and then the subsequent renewal of it, but what the impact was related to before the diversions were in place, so that you can see the complete picture of that impact to inform you on what decisions you should make about protecting that resource as part of any future lease or license or permit. Okay? It's got to be that comprehensive look of the entire impact, not the incremental look from one day to another when you continue the permit. These are very important principles and decisions to respect. Okay? And so what happens with Judge Nishimura's decision? She took a specific instance involving the use of water under a permit, some permit, that was contested by our clients and held over by the Board of Land and Natural Resources for the past 15 years. And she looks at this and says, how can this be? Revocable permits are supposed to be temporary. And she invalidates and rules illegal those 4 permits, nothing else. Okay, that's what a lawsuit is. You take a set of facts and you apply the law to those set of facts and you come out with a conclusion. This doesn't apply to Ka'u. It doesn't apply to other parts of Maui. It doesn't apply to KIUC's water. Those facts and those circumstances are different, and any court would not apply the facts of A and B situation to KIUC or Ka'u or anything else. That ruling does not impact those other limited number of permits that may happen to involve water use, and not those hundreds of others that simply involve the use of land. Okay, so these Maui people are not insensitive to those concerns. Absolutely, they, and Edwin has told me repeatedly, hey, we support the Kula farmers. They should be on. We don't want to take water away from them. We like farmers. We're farmers ourselves. They produce food. We produce food. So the Kula farmers, especially under the stay issued by Judge Nishimura, are absolutely protected. Every water user, every one of those 35,000 people who are domestic water users, every one of those Kula farmers are protected. End of story. There is no impact on them by that ruling. Okay, people may want to imagine that, oh, this ruling, in this situation, they rule these revocable permits illegal. Oh, I have a revocable permit. Oh, I'm threatened. That's not how this system works. You've got to have a lawsuit that applies to you and to your permits to have a ruling that makes it illegal. That ruling, Judge Nishimura's ruling applies to 4 permits. That's it. Okay, that's got to be an important thing to remember, because everybody in this room, I think, is sympathetic and would support the small ranchers and farmers that feel threatened. But that's why we have this task force. This task force that has been set up by Suzanne Case and Kikoa Kauriva to investigate what to do under this policy rationale is the vehicle to figure out what to do in light of all of these laws and all of these protections I've outlined in the past. This bill should not be targeting a simple reversal of this decision, which is pinpointing and targeting the 4 revocable permits, okay? Because it is going to have unintended consequences on all those other laws that are in place that I just recited. It's going to have an impact on it. For example, does it sanction the allowance of continued use of water without an EA, which is supposed to be required before that decision is made? That's something to be thinking about. You know, that's basically 45 years of history of this law that has that rationale to have environmental review and disclosure before a state decision is made to commit a resource, especially a public trust resource. Okay? And by the very language of the bill, it talks about revocable permits that involve a previous request for long-term disposition of water that has been held over. That doesn't apply to the Kau and Kauai people. Their revocable permits have not been held over. And frankly, the law allows, under the proper conditions, the BLNR to renew those permits every year. That may not be good policy, but that's what the task force is for. So those concerns about those permits should be addressed at a task force, not to you. You're taking a sledgehammer to fix this problem. It should be a surgical knife. And it is a surgical knife, and it applies only to ENB. And that's why this bill should be killed. It is ill-advised. It will compromise 150 years of legal developments that protect those interests that are so dependent on water to continue the cultural traditions of ancient Hawaiians that we as a community should all respect, because that's what makes us who we are. This is Hawaii. This is not California. This is not Colorado. We got Hawaiians here, and they're special. I'm not Hawaiian. I think they're special. I hope you guys think they're special. And their culture is special, and their values are special. And that's why these laws went into place. But if you take House Bill 2501, you will be taking a sledgehammer to shatter all that intricately designed legal structure that has evolved over these several decades to protect these values. And it goes as far back as 1905, in the very case that AMB litigated in their interest, that applies to us in our interest today. Okay, lots of things to think about. This bill should not be used to basically take away all of those rights, all of those interests with this one fell swoop. And so I urge you, allow the problems to be solved in the forms in which they were designed to be solved. Let these other revocable permit holders go to this task force and have some kind of measured policy discussion about what to do with them. This ruling does not affect them. Judge Nishimura's rule is not affecting them. It affects only A and B. And until A and B can come to you and specifically with numbers justify why they can't have enough water to shut down their plantation, taking out 13,000, potentially 12 to 13,000 acres of sugar immediately. They're not planting on those lands. They're going to end up with 16 to 17,000 acres at the end of December of this year. That means 12 to 13,000 acres are going to be taken out immediately. That's going to have a water impact. And if they can already pump enough water, groundwater, to meet that remaining sugar plantation need, that doesn't even account for the water they can take off of their lands coming through the ditch system, which is way more than what they could possibly need. Until they make that showing, do not be convinced that you need this bill. Thank you very much.
Thank you. Next testifier, please.
Aloha, representatives. My name is Nomi Carmona. I'm the organizer and lobbyist for Babes Against Biotech. Right now we have about 53,000 supporters, of which about 40,000 are in Hawaii. And we organize heavily in East Maui in that district, and work with a lot of constituents there on the ballot initiative as well. So we have a lot of roots and we have a lot of members in Maui that are very concerned about this legislation. So just off the bat, I want to just kind of clear up some misinformation, which I think has already been clarified. I just want to make sure nobody's being taken advantage of and not knowing any better. There is a singular temporary holdover permit for A and B. So this legislation obviously is specified to benefit one billionaire corporation, not the other farmers who may have been misinformed that they would be impacted. So just to make sure that you're dealing with the facts and aren't being confused or mired by that information, let's just have that very clear. The other thing, a lot of other things, I'm sorry. So A&B is taking advantage of a lack of education about their practices, which is kind of assisted by the lack of environmental review. This process has never undergone any environmental review. And in fact, they could actually apply for a revocable permit like all these other good farmers and ranchers have done for that large-scale use and complete an environmental impact assessment or an EA, which is required under the law. This legislation appears to be very thinly veiled in an attempt to skirt that environmental review, to skirt judicial review when it comes to the court's recent ruling, and to get around the law. It's still in appeals, it's still in litigation, there's still a contested case going on. It seems like a very poor time to attempt this type of legislation. I think that we should allow those processes to complete themselves. And I think that we have to look at the fact that they have been getting a special privilege that is not given to anyone else in the state. I wish that all these other farmers could get 1,000 gallons for 1/4 of 1 penny, for less than 1/4 of 1 penny. But they're paying 75 cents for every 1,000 gallons. Well, A&B is, and has, for the foreseeable past, when they have had revocable permits, which expired in 2002, they have paid for 33,000 acres of crown land use and billions of gallons of water, $160,000, which I think is unfair. I would guess that our farmers have probably paid more than that just based on the fact they're paying 75 cents every time A&B is paying less than 1/4 of 1 penny. So I think after hopefully this committee votes to indefinitely defer this legislation, and hopefully after DNR eventually enforces restoration, we should look at those kind of sweetheart deals. This appears to be another one, and it's not. It's not a very complex cover. It's pretty straightforward what this legislation attempts to do. And I do see misinformation coming from A&B's side, which would financially benefit them. So I think it's something to think about, okay? A&B could also get a stay, like the county did, if they're willing to explain why they need that water. Now, in their own court documents, because you know my issue is a little bit different than this, so I wanted to see what has A&B said, what has A&B admitted on the record. And in document C-137, in something that I can send to you that you have already received as well in your charts from NHLC also, they have admitted they have 132 million gallons per day of their own private sources. That does not include at least 20 million gallons from Navai Eha. Okay, so if they were, right now they're cultivating 17,000 acres, okay, with hemp. I'm sorry, hopefully with hemp someday, but currently with sugarcane. Obviously the water duty for a diversified agriculture, which does include the popular notion of hemp, is 2,500 million gallons per day. So even if they were to cultivate all of their 33,000 acreage, they would really only need 82.5 million gallons per day to cultivate all their acreage in diversified ag, including hemp. In addition, their contract with the county is 9 million gallons per day. So if they have, 132, plus they have 20 from Navai Eha, that is plenty of water from their own private sources to cover diversified ag for the entire acreage and their county contracts, which continues to provide the upcountry residents with water. They're fine. This bill will not affect them. In addition, actually, even if they just cultivated the 17,000 acres that they're going to transition from sugar, hopefully to diversified ag and hemp, That would be 42.5 million gallons per day. Now, they are losing almost that much every day on average from their own private sources due to unlined tanks and leaky old pipes, which they could also choose to fix and tap their own water resources rather than continuing to take the public's water. Okay, so 41 million gallons a day is a tremendous lack of water stewardship, in my opinion. I think that if they were to fix that, maybe they wouldn't need to take our water. They don't need to take our water as it is. Excuse me. So nearly as much as they would need for all diversified ag is lost every day from their own private wells, which they can fix. I feel like there's two sides. I agree. The judicial side is very clear if you're actually looking at the facts. The environmental problems are very clear. I don't think that they could get past an EIS or an EA to build a diversion today, but if they could just explain to the county why they need the water, they could get the stay, or they could fix their tanks and get another 41 million. Either way, they have 132 plus an additional at least 20, possibly 30 from Novi, I'm not sure, less the 41 million gallons. They have at least 111 million gallons per day of their own water, according to C-137 submitted in their court documents and their own admission. And the maximum that they would need, I think I've made clear in the averages for diversified ag and the county usage there. Try to wrap this up. I try not to repeat things that other people have made clear, but I do think that, to me, in addition to the judicial and environmental data, this is, I agree, a moral issue. I feel like you can kind of take one of two positions, generally speaking. You can take the side that says, all right, A&B is a big business in Hawaii. They're a billionaire corporation. They control a lot of land, and they're practically an institution. Gee, what a business to help overthrow Queen and then take advantage of an occupied people and their resources, which they've been monopolizing for over 120 years. Wow, what a business model to be a billionaire corporation and to have been able to get away with only paying $160,000 for billions of gallons of water. You can kind of say, gee, that's a smart model. And you know, then they have plenty of money to give to campaign funds. And then they have more influence. And they're able to even introduce legislation like this, which should be an affront to legislators elected to defend the public trust, which I think nobody got into office to help giant corporations steal water from local residents and farmers, pretty sure. And it would be great if they could get those deals and we could renegotiate this and make sure they have water to decrease our 94% food importation in the meantime. I think that the other side of this issue, one side says, oh, A&B is brilliant. Wow, what a business. They really have a plan here. The other side says, wow, these people have been overthrown, disempowered, their water's been stolen for decades, billions of gallons of water, they have not been compensated. Kalo farmers have to close up their farms. Some of them have died waiting for the completion of 15-year, 3 contested cases, which are, 2 of which are still ongoing. I think that either you say, I am with the public trust, which I swore an oath of office to, or you say, gee, A&B really needs our help here. They don't have enough money or resources or water, and none of that is true. So I think when you look at it from a logical standpoint, if you're looking at the actual facts here, A&B can afford to fix their tanks. They have plenty of money for lawyers to ask for a stay from the county. They have plenty of water for diversified ag for their crown lands. They've gotten a really fantastic deal so far. As a matter of fact, I would suggest that they probably owe back rent in a just world. But in the meantime, I am committed to protecting the water. I think that a lot of my Hawaiian friends and a lot of my environmental friends and tens of thousands of people are just beginning to get an education about the monopolization of our natural resources and our water. And if we have an opportunity to protect public water rights and protect the people of East Maui. I agree, I'm here to protect water rights and the public trust. Then I think there is only one clear solution, and I hope that this is deferred indefinitely, and it ends here. Because I don't want to have to go back and get everyone else to explain why you shouldn't legalize corporate water theft. I think it's plain to understand, and I hope that, I agree with Auntie, where is your compass? Where is your compass on this vote? Because we have to put close attention because the natural resources are being damaged, they're being destroyed. They're literally wasting an average of 41 million gallons a day of water that our farmers would very much like to have from their own sources, which they deserve, which belongs to them. So I apologize for the diatribe, but I hope that I've been helpful in laying out this information for you, and that we can count on our representatives to uphold the public trust and their oath of office by voting to defer this measure indefinitely. And I hope I never see anything like it up in this legislature again. That is my hope. Mahalo.
Okay, thank you. Next testifier. Okay, seeing none, let's move on to questions. Members, any questions? Oh.
Sitting at the back.
Okay. If there are any other testifiers, please step up to the table. Okay, go ahead.
You guys have one of the hardest jobs, and so let me just say that as a disclaimer, that I respect you. That being said, I think this is so audacious. I just can't believe that we're here. I'm so confused. I had no idea that the ledge could trump the courts. Somebody help me out. Whatever the reasoning is that brought us here, I just need to share my personal story. I'm from East Maui. I'm a cowgirl. I was raised in Kipahulu. I know the value of water. I married into the Keonai district. In my lifetime, I've just totally shadowed this issue because I come from a long line of participating citizens. My grandmother was across the border to fight for union rights. My mother had to speak against her own employer. You know, it's just in my blood. On top of the fact of marrying into a kalo farming family, I was prepared to marry a farmer, and that didn't happen. I had to take a 180-degree shift in what my plans were in my young 20s. It is a fact that this small area of Keonai, Wailua Nui, in the 20 years that I've been, an adult, a voting adult, 85% of the able-bodied, not just men, citizens that could farm and that might have farmed have either died, gotten addicted to drugs, or they're in jail. And this is not a fact you're going to find online. It's not a fact you're going to find from any statistics or anything. This is from the community. And I'm here speaking on a lot of my friends that have already mocking. I feel like I have their spirit with me here today. I was junking them up in a shaka pole if I should come here today. And they're the ones that moved me to come here. And I just need you guys to know that I feel like that is related. It is socially related. I have uncles and they've got Connie have a lot of energy, and these men, we need to keep our men busy. They've got energy and they've got brawn and they've got fortitude and they're protectors and it's hard work to farm. It's really hard work to farm with no water, and we face those challenges. I stuck it out as long as I could. I've still been a part of the community, even though I certainly didn't get married. I have children that are from this area. I have grandchildren that are from this area, and so I kind of feel like I'm speaking on my grandchildren's behalf today. this is my personal story, and I'm glad I was able to get through it without crying, honestly. I just want to say that I just want to remind this body that the last time such an outrageous, illegal story persisted in the headlines, the New York Times had an artist draw the pictures, the headshots of those people, and it was on the front page, if anybody remembers the Pauahi Bishop trustees. And I just beg you guys not to go down with A and B. You know, I have friends that are Baldwins. I went to Seabury Hall. They're best buddies today, you know, and they agree we can work this out. There's a lot of little things to untie and knots and things to figure out. Nobody's just gonna okay the water one time. You know, if it needs to be an appropriation for some sort of translator or a mediator to A and B, talk to the farmers, or whatever it is, figure it out. It can be done. Don't be scared by like, oh, wow, get choke work for doing that to figure this out. Please, we can do it. And then, you know, I always like to end on a high note. My name is Faith. You know, it's a big name to live up to. I just want to tell you guys that it doesn't have to be painful. It can be joyful. You know, just imagine this. Just imagine all these big local boys, and you see some farmers, there might be some in the room, you've certainly seen them in the back. Big local boys, taro farmers, you know, barefoot, no more shirt in the taro patch, and the water is let go. You know that day, when that day happens, I'm personally sending you guys an invitation, because it's going to be a holy day. So I just want to end on that positive note that this is possible. It doesn't have to be painful. It's going to be joyful. Thank you for your time.
Aloha mai kākou. My name is Pohai Paikala. I am from the island of Maui. I am currently going to school here at UH Manoa. My family does originate from East Maui, mainly Ohana, but they do branch out to Kelanai. And a few of them are taro farmers, my uncles. So growing up, I've never ever seen hihiwai before, which I think you folks know as a native species. Not a day in my life have I ever seen that or heard about it or what you can do with it growing up. And I've never once saw opai or oopu in East Maui. I have before in town, but not in East Maui. You know, you don't need an EIS or an EA to see the damage that has been caused to these lands, or to see that the lives of these of the community is being immensely impacted by the diversions completely. And you don't need to see the EIS. You don't need an EIS or an EA to see that the native rainforests the health of the native rainforests have completely depleted over the years, hundreds of years, and it's completely hewa. You know, how can you let this continue? It completely just suffocates our people and the culture. It suffocates our culture, the people, their livelihood. This is what they need to live on a daily basis. You know, they need this water. If not, they have to move away. They need to find other places to work. And the culture that's continued mainly there it doesn't continue. That legacy just disappears. How does that get passed down to the next generation? Like I've said, I've never seen a hihiwai before. You know, I believe in the 1930s, the agreement, it states that it promises a stream restoration program that a stream restoration program will be initiated, and as long-term agricultural needs reduce. The public obviously views this situation as AMB shutting down, that agricultural use is being reduced completely, you know, and how does that not decide or help you folks decide that we do need this water? Yeah, mahalo for your time and listening.
Thank you.
Aloha mai kākou, o noho i o ho'olea ka'eo, he kupa anak mokupuni o Maui. Mahalo board for allowing us to speak and share our stories with you all. As a resident of upcountry Maui in Kula, I am grateful for the water that comes from the moku. of Ko'olau and the east side of Maui. However, it should not be taken away at the expense of the people of the Ko'olau and the environment. Like what is being done today by taking more water than is necessary. A&B continues their stronghold and thievery from the time of the overthrow until today. How much longer will the streams run dry? When will they realize enough is enough? Is it when every single o'opu have died, or every hihiwai is unable to move from the Muliwai to the Kahawai, when the last kalo farmer can no longer farm, or when the fish in the areas continue to be impacted? Then will these impacts make sense when my culture can no longer be practiced? These aren't just things that ancient Hawaiians have done. These are things that the community, especially in East Maui, continue to do. But with the streams running dry and with the amount of water that's being taken away, that is, their traditions and their customary rights are being taken away from them. So as a student, as a young Hawaiian and a voter, I urge you representatives to oppose this bill to protect their rights and put the public over profit, not the other way around. Mahalo nui.
Thank you. Anyone else wishing to testify? Please come up.
I'm sorry, I just need to contribute a number. Mary Ann Haupoa, her name might have been called earlier. She thought she was going to be here. That's my daughter. She started a petition. There are 772 petitioners that signed a petition specifically to SB 3001 and HB 2501. There was one, we scanned the list as best we could. There was one under 18 petitioner and about 10 that were out of the country, just for your information. And you have that in your email inboxes, I believe. And there's comments from 272 of those 772 petitioners. Thank you.
Okay, thank you. Anyone else wishing to testify, please come forward now. Okay, see none. Members, any questions?
Thank you, Chair. First of all, I want to thank the East Maui people for coming over and testifying. And I'd like to take DLNR first, please. First of all, I guess a lot of confusion going on, clarification on the permit, holdover permit. Who does the permit pertain to on the holdover permit?
Hello, Representative. Again, Keikoa Kaluhiwa, First Deputy for DLNR. I am also joined, I hope you don't mind, by Kevin Moore from our Land Division, which has oversight with issuance of revocable permits, as well as our Water Deputy, Jeff Pearson. So with that, I'd like to ask Kevin to respond to the question.
Kevin Moore. I believe there are 4 water permits for East Maui. 2 are to EMI and 2 are to A&B. Those 4 were put on a holdover status, meaning they would continue until there was some resolution of the litigation.
So Kevin, all these years we've been holding over. Why?
Because I think one of the reasons is A&B and EMI were in the process of doing the EA-EIS. It hasn't been completed. I think one of the reasons that I've heard is that A&B wants to be sure that if the water rights go out to public auction, which is what the statute provides, and they are not the successful bidder, that they would be reimbursed for conducting the EA-EIS. But the department doesn't have a lot of leverage to force an applicant to, conduct the environmental process quickly. The department's leverage would be to not renew the permit and to stop the water consumption.
I think that's really a shame. After 30 years, you cannot force somebody to do anything. That's shameful on the part of DLNR. What my biggest question is, because A&B does hold those permits, and it's because of you guys where does it leave the service provider in servicing upcountry Maui of the 30,000 people? If those permits do not get renewed. Because they are the service provider, correct me if I'm wrong, to the people of upcountry Maui, Waihuli, Kula, Keokea, and also Haiku. Where does that leave those people if we're stuck in limbo on these permits?
Yeah, I think there was some mention previously about the county of Maui seeking a stay for some portion of the water use for those end users.
You talk about stay. Define the word stay as stay would be. I think that's a better question that needs to be answered when one entity requests the stay. What, stay for 5 minutes, stay for 5 days, stay for 5 years?
Well, unfortunately, it's kind of venturing into a legal field, and it might be better directed to our Deputy Attorney General who's assisting us on this case. But my understanding is it would be a stay of a lower court's order by an appellate court until some point in the litigation.
Let me just clarify something. I am in big support of returning water to our East Maui streams. Of course, as we know, CWRM will decide on the 29th on inflow streams. Yet you guys have been holding back all these years. Would it be A&B, would it be upcoming farmers that coming in on the permits? Where does that leave the rest of our neighbor islands that are also affected and impacted by this?
Yeah, I think we're waiting to hear from our AGs what the actual impact's going to be to other water users from that litigation.
Once we get the impacts, KINCOA, the task force that you guys created, of course, the task force can take years upon years. I mean, we're looking on findings and we're looking to help, alleviate the situation.
Sure. Thank you, Representative. If I can just defer over to Jeff, who can tell you a little more about the task force.
Yeah, Jeff Pearson, Deputy Director for DLNR at the Water Commission. The chair just recently, as you most likely have read in the paper, appointed a task force that I am on. She's given us the direction to come up with recommendations, policy, recommendations for administrative rules, whatever methods we can have to help resolve some of these obvious weaknesses in the program by the end of April. So we've met one time. I think it's a good group. There's administrators on the task force, and then there's a few outside people that are knowledgeable in the planning and real estate side. And the idea is, right now we're scheduling to meet weekly, and we're going to try to do our best to come up with fixes, doing the best we can, finding ways to resolve some of these obvious issues, and hopefully we can have something coming this direction. April or May is the goal by the chair, and of course we're going to try to do our best to meet that goal.
Let me jump back, Kiko. The permits as it stands, does it directly impact the neighbor island farmers and ranchers with this permit?
Again, I think we have to consult with our AGs on that to tell us what the impact is, but there's at least a potential for it, I suppose.
There's a potential to impact. What is the precedent are we setting in renewing on the RP levels? And the reason why I ask is within the same reasoning with DHHL and how they go about doing their RPs. And I don't like the word RP because as a farmer myself and a rancher who grow food, we put into a precarious situation where if we're investing in ourselves to grow food or raise cattle, we cannot get a loan from a bank and so forth because of the turnover of that RP. So I think that's a question that needs to be answered for this body and for everybody that's at stake here. for the ranchers and the farmers, aside from what A&B has on the table? You know, so I would like to have that answer sooner than later.
Representative, I'm sorry, I just wanted to get back to the task force. That's one of the questions that we are going to be looking at. The time frame, just so you're clear on it, we want to have concrete results from this task force April 30th, and then have an informational briefing for both the House and Senate Water, Land, and Ag committees sometime in May, June. So a fairly quick turnaround as far as what recommendations they have for us. Now, I will say, just generally speaking, and again, I'm not an attorney, I'm certainly not a water expert, but I feel that this issue that has been, you've heard such passionate testimony today, this is the result, frankly, of our public process. This has been litigated for decades, as you have heard, and it is frustrating. I, for what it's worth, really believe this administration, Chair Case, are adamant in finding some resolution for this dilemma that we face here now. And I would also like to say that, you know, the issue of revocable permits, as you're alluding to, if we require long-term lessees to do an environmental assessment to get the long-term lease, those are considerations we have to factor in for small ranchers, farmers who may be not be able to afford doing the environmental assessment. So these are the things we're looking at as a task force in the next few months.
Well, and that's the reason why my question is because we're asked to make a decision on this bill that could directly impact future of farming and ranching. And when you put that on the table to us, that tells us, does every one of us have to do an environmental assessment as a farmer and a rancher? That's my question to you guys, to the task force, to the AG. Because we know what an environmental assessment costs. We're trying to grow food, so every new farmer, we talk about sustainability. We have to, is that something that we're looking at? If that's the case, we just import 100% of our food. At the same time, the question still remains, how much of the water goes back to East Maui? For them to farm and live off the land as cultural gatherers. You know, so, and I get more questions, but Chair, I'll just go deeper and let somebody else for now.
Okay, for the DLNR, can a DLNR renew a revocable permit without requiring an EA or an EIS?
That has been the practice. There could be arguments that, you know.
What kind of argument?
I suppose someone could argue that continued use in some situations, looking at cumulative impacts over time, might not be exempt under the statute.
So it's possible. And then, okay, and we've already established that it's possible in the context of the renewal of or issuance of a long-term lease. Is that fair to say?
People have taken that position. Yeah.
Who?
Well,
the board?
Well, if we're talking, for example, the Mauna Kea summer lease, there was an issue, you know, about whether the board could grant the University of Hawaii a new lease without doing an environmental assessment. There were arguments on both sides of that. But the specific question hasn't really been answered.
Okay. Okay. I know you're not going to answer this question because your deputy's not here. So maybe I'll ask NHLC. Can one of you stay up? I'll call you guys back up in a second. From a due process standpoint, in your mind, what is a reasonable tolling period that a contestant in a contested case is entitled to regarding a BLNR decision?
That's a very good question. I would say the only thing I can answer is what is not reasonable.
Well,
15 years is not.
In a circuit court context, when a stay is issued, what's a reasonable tolling period from a due process standpoint?
Sure, it's a stay pending appeal. That stay is good until the appellate court issues its ruling. So from my experience with the appeals that I've had before the appellate courts, It takes anywhere from 2 to 6 years to get a ruling from the appellate court. That's more than enough time to get an environmental study done and go through the proper process for getting a permit. It's a stay pending appeal. It is not 5 minutes, it's not 1 year, it's until the appellate court rules. The appellate court could rule in their favor and say the judge was wrong. The appellate court could say she was right. During that time, they have every opportunity to do the environmental assessment, environmental impact statement that they should do. I would also mention that the county has 2 other diversion systems that divert water to support upcountry Maui. There's no permit for that, as far as we're aware, and they're still using the water. The question is, what's DLNR going to do about it?
So in your mind, is in the contested case when the board decided to grant holdover status, is that analogous in your opinion to a circuit court issuance of a stay? Is it fair to say that holdover status is the equivalent of an administrative equivalent of the granting of a stay at the court level?
I'd have to say no. The circuit court has the power. There are rules that apply that allow them to issue a stay. There are no rules that allow the administrative agency to issue this kind of holdover.
Well, from a procedural standpoint?
From a procedural standpoint, no. If you read what's coming out of the Supreme Court right now is that due process considerations apply. The effect of what they've done is grant a permit while the contested case is proceeding. And the court has said, I'm sorry, that doesn't fly. So no, I'm sorry, it's not the same thing. And especially not when it lasts for 13 years and there's no end in sight.
Well, that's why I asked about the tolling period. What's a reasonable tolling period when an administrative ruling is appealed to the circuit court? Is it fair to say it's analogous to the tolling period when a circuit court ruling is appealed to an appellate court?
No, because we're in a contested case. So it's a completely different issue right now.
From a due process standpoint, it's a pretty similar issue, wouldn't you say?
No.
Why not?
Because right now, the BLNR is the one in charge of proper management of these public trust resources. If this permit, I'll tell you now, if this permit was applied for today, the Supreme Court would say, no, you cannot issue this so-called stay while this hearing is going on. You cannot do it. They've been able to do it this far, but I mean, really, if they went through the available process.
So why? Why would the Supreme Court?
Because what they've just said, just in December, is that you cannot effectively issue the permit while the contested case is going on. You can't allow this use while the contested case is going on. Now, in this case, we have a unique situation.
Well, in that context, they were talking about the actual issuance of the permit. They weren't talking about some sort of temporary remedy.
Right, you're right. And I suppose if we were talking about a temporary remedy, we could conceivably think of something, but a temporary remedy that lasts for this long, when there's really no incentive to complete this EIS, is not
so
temporary.
Again, from a due process standpoint, what's a reasonable tolling period?
That's a good question. I don't know. I can't say today. All I can say is what it's not, and what it's not is 15 years.
Attorney General's not. Oh, right, they're not here. Okay. In your opinion, okay, BLNR. Thank you.
DLNR?
Or DLNR. Okay. Cool. Okay, is it fair to say that a permittee, whether it's a revocable or a long-term permit, that a permittee would only be entitled to holdover status if their permit renewal was subject to a contested case?
I'm afraid that's too much of a legal question for you.
Okay, NHLC.
Can you ask that again? Sorry.
Yeah. Would it be fair to say that a permittee would only be entitled to holdover status if their permit renewal was subject to a contested case?
Would only be entitled to holdover status under this amendment?
Generally speaking, whether it's a revocable permit or a long-term permit.
You mind if Alan or Camilo comes? Yeah.
Yeah, thank you guys. I know that.
You're asking if, would
I'm talking
anything
about the
be-
mechanism of holdover status. Isn't that a status that's only granted to a party in a contested case?
This holdover status has only been granted to A and B. It's not something that's,
But it was granted as a function of the contested case over the long-term lease renewal, isn't that?
that's what the board has said.
Okay. So this is the only example that we have.
That's all that we're aware of, and that's all that the AG could point to.
Okay, so you're not willing to take a position on whether or not a permittee in general, revocable permittee or long-term permittee is entitled to this administrative mechanism that the court characterizes as holdover, or that I guess the legislature is the bill is characterizing as holdover status.
Right, there's no mechanism in place right now. I would say that the revocable permit process is the mechanism in place. And there are mechanisms to protect the small user that is not going to have a big effect on, by using water for their small parcel. There are exemptions to EAs. The board could say that this permittee is not going to have such a huge effect that they need to do an EA. There's specific criteria for exemptions that the board can follow. And so no,
if we have a party that's in a contested case over a permit renewal, okay, are you saying that there's no, that the DLNR is not entitled to authorize some sort of temporary remedy to the parties in the interim during the contested case?
in terms of a permit, no. In terms of a lease, yes. There is statutory provision for a holdover authority for a lease.
Okay, what are the conditions of that?
It is, their lease expires, they can grant holdover authority for an additional year. Until they, I suppose until they go through the process of renewing. This is in chapter 171.
Okay, so would you say that a year would be a reasonable tolling period to a contestant, to a BLNR decision?
Yes.
Okay, thank you.
Okay, thank you, members. Any other questions? Representative Ward.
On behalf of Sierra Club and E and B. There was an earlier discussion about models, and I kept thinking that this is a scarcity model. There's not enough water. And Sierra Club came up with, hey, there's enough water. Are either of you hydrologists, so we can really get down to some numbers? Who needs how much and what's the allocation? Or does anybody have the ball scores on how much water is running, how much water is needed by the Kalo farmers, how much is needed in the transition for the A and B diversified ag? I'm a metrics guy, and those things mean a lot, because if there's enough water, that means we got a management problem, we got an allocation problem, and a governance problem. So just throw out some numbers. How much, if we had a pie chart saying, here's the universe of all the water, this section is A and B, this section is the Kalo farmers, etc. What does that pie chart look like? Does anybody know? Would you know?
So, no, I just want to say that I believe going forward, there, as Marty said, there is going to be enough water for all. So maybe the best measurement right now, it's not official, but Dr. Miiki, the hearings officer, came out with his recommended decision for the IIFS, and that has yet to go to the commission. So I don't know, can we talk? It's out there, but in it, he identifies how much water is needed for the stream, how much water is needed for the taro farmers based on what was offered into evidence, and how much would be reasonable for A and B and the County of Maui to divert for their uses. And based on that document, he split the pie up. And what I said today is that we are likely going to, very highly likely, going to use less than what that pie was at the time we had to offer the evidence, which was 9 months ago, before we knew we were going out of sugar. So I think there's a solution.
It's coming. So this is not just a hypothesis. It's actually a possible, real solution.
Yes, but that has nothing, and this had nothing to do with the lease, right? That's it's the how much water and how to break it up is not affected by this bill.
But But the whole point is, it's like who's sleeping in the bed with the sheet on their side and they pull it and then the toes come out on the other side of the bed. That's kind of the model that I got of the scarcity model. How many taro farmers are there now and what is the productivity? Does anybody know that figure? Do we have a... how many taro farmers and what is their productivity? Could you join the ladies here? Okay.
You can sit with John. You fight.
Ask you the same question in a different way.
How many taro farmers
Yeah,
we
the
got?
needs, the water needs of the taro farmers.
You know, I did not do the studies, but Mr. Rupun did it. I think it was something like 300,000 gallons on it.
100.
Yeah, it depends on.
Depending on the elevation and flow. Oh, we don't get that. We got crumbs. You know that question you asked? Well, my toes are sticking out. And it's been out there for a long, long time. If anyone can give you the true answer, it's her. On how much water they got. Well, we got the sliver.
But how many taro farmers are there?
Oh,
that's
shoot.
what I'm sure the first one.
You know, I think just in our village, we got about 20, and there are much more. What I witnessed through the years and being in this water case, it dwindled. Simply, you cannot farm without water. I have my son, 2 of them, and my youngest son, I'm hurt. I got pictures of him, dry land. In a wetland taro patch, we farm. Now it's the taro farmer out here. Dry land, crack, with a 5-gallon bucket, water that he carried to the lo'i and had to harvest in a 5-gallon bucket. So we've been at the tail end. And what has happened is, and I think others mentioned that, people started to go away from the farming. So it got smaller and smaller and smaller. And we also heard about invasive species. East Maui, and I go to the high elevations, above the ditches, for one reason, to show the younger generation what is up there, where you gotta go and what you gotta look for. Sir, there has been an impact beyond your imagination.
How many acres used to be in Taro and how many are there now? 20 farmers you said? Or
we had about 20. I would like to see maybe over 10, 15, just in where I'm at. We have 2 different areas. When you deplete the water, and what happens, you lose the plants, the seeds. It takes 1 year to grow. So every year, you would get less and less and lesser. But I can honestly say to you today, there's more farmers, young farmers, because of the advance of the water case coming back.
So you think when the hydrologists or the judges do the numbers that there will be enough, there's enough water to go around if it's distributed properly?
Oh, there's more than enough, sir,
There's more than
to serve Maui. And when I hear these farmers in Cuba, they go out without water, or up country, it won't happen. It's more than enough.
So the sheet's big enough to cover your toes, their toes, and their toes, and everybody's.
You can cover that in a Maui.
Okay, now I have for A and B, I have a null hypothesis. It is, if you don't do diversified ag, if you don't get the water, what happens?
Less water, there's less agriculture that we can do, right? So
Because someone said that, well, you're going to start growing houses. Is that in the realm of possibility?
we are committed to pursuing this diversified ag model. Can we tell you what the end of the story is going to be? No. If diversified ag was so easy, you'd see it all over all of the islands where all the sugar went out. It's not easy. Farmers tell you it's not an easy life. Cowboy is not an easy life. The same, right? But we're committed to try. I'm going to take small steps, see how they do, and analyze it, see, hopefully grow bigger trials of a lot of different crops.
The last part is, when do all of this litigiousness come to a conclusion with a yay or a nay, or these water usage charts, etc.? Do you know that, or is that maybe Alan? Do you, or DLNR? When do we say, okay, fish are cut bait? It's time to say, here's the decision. When is it? We got to sit around and wait for 100 years?
I've said it before, and it wasn't an original saying, but whiskey's for drinking and water's for fighting. But,
how did you come up with that? It's getting late.
Is that Mark Twain? Okay, I'll be as brief as I can. The contested case hearing, as Representative DeCoit said, on the 29th, there's going to be is a deadline for exceptions to be provided by the parties. After the exceptions, then I think they allow 30 days to review the exceptions. And then once the exceptions have been reviewed, it goes in front of the commission without testimony for oral arguments. So that'll be scheduled. So that's what we're talking into February. Says say March 1st, April 1st. Sometime after April 1st, there'll be a schedule to have oral arguments in front of the commission. And then after the oral arguments, I don't know if it'll be a following commission meeting but the timing will be fairly soon after April 1st, that the commission will look to make a decision on the contested case that Larry Mike is.
So the answer is next summer?
Well, yeah, I would think that there could be as soon as this summer, correct.
As soon as, but as late as?
Well, I'm saying, April will be the oral arguments, and then the commission will decide after April. Now, one of the options that the commission could do is ask for the contested case to be reopened, because the contested case right now views the facts that were at hand at the time of the contested case hearing and the presentation of facts, which I don't know the date, but it was a while back. And HCNS, of course, had not announced that they were closing down their sugar operations.
When is the exact date of the close down?
We'll finish our last harvest the end of this year,
So, end of the calendar year?
end of 2016.
So therefore, those facts of them closing down is not part of the contested case with the facts in hand. Of course, everybody knows that now, and likely when you have these exceptions that come forth that are due by the end of this month, that there's going to be a pretty good guess that part of the exceptions are going to be discussing this new issues with HCNS.
I want to maybe clarify a little bit on this, how much water is coming out of East Maui. East Maui irrigation extracts over 60 billion gallons a year. They take out of there over 60 billion. And that's not to include the 100 million that they can pump out of their aquifer. And the county of Maui is saying that the sewage treatment plant that is close to the airport, that water can be used as gray water for agriculture purpose north of the airport. I do not know the exact amount of water, the millions of gallons that they are talking about for agriculture. So over 60 billion gallons of water is more water than the island of Honolulu use.
That's why I'm looking for that pie chart to see.
It's a big one.
And
they got, let's say they got 15 16ths. We got that 1/16. That's the chart.
I look forward to the chart that shows that. Sierra Club,
The only
did you?
caveat that I would add is first that the water code has already made a decision about how that pie chart looks, and it says first in line for water is the stream and the natural resources there. The second in line is terra farmers. Third in line is diversified agriculture. So the question the question to be asking is not how many terra farmers are there that we need to provide water for. Terra farmers, however many they are, they get water. The question you should be asking is what diversified agriculture is going to take place, where, and how much water is needed.
I would beg to differ. The state water code does not prioritize in that matter. It lists a lot of different uses but the basic test is public benefit to the public.
The public trust first public trust issues in the water code, they list 4 public trust issues without any hierarchy. Public trust issues are water for domestic use. It's water for to keep the water in the streams. Of course, that's one of the 4 public trusts, is to keep the water in its natural state. Water for domestic use, water for traditional and customary rights, and water that's reserved for Hawaiian homelands.
Okay.
And they're supposed to be looked at in equal status.
My last question is, Chair, regarding the missing Attorney General, because what you guys are talking about today scared everybody. In fact, is the Kauai Island Utility Cooperative here, Jim Kelly? Is Jim still here?
No, he left.
I mean, the interpretation is that it affects everybody versus it only affects this one. I think was what Alan had said. This has got a lot of repercussions, so thank you guys for testifying, but you really make our job difficult. This is not a piece of cake, it's not a cakewalk.
You can punt it to the Water Commission. That's the entity that's been identified.
Well, it looks like it's
already.
been punted continually forever and ever.
And we're this close to decision.
Thank you. And thank you for serving.
All we ask is let the river of justice flow freely.
Well said.
Thank you.
Thank you for serving.
Thank you. No, not the other. Is here? Oh, Jeff. Oh, excuse me. Sorry. Maybe, I'm not sure if it was you or who from the LNR, but I want to clear it up there because I thought I heard you say AMB wouldn't pay for the EIS if they didn't get the permit. Did someone of you say that? Did you say that? Okay, I'm sorry. What did you say?
Yeah, what I heard, and I don't have first-hand knowledge of the details. It was discussed at a board meeting that I attended on the local permits for East Maui. That was one of the issues raised, as I understood it.
You want to comment about that, Brandon?
Yes, I have some documents here that show that when we first applied to the BLNR in 2001 to start the lease process, we offered to do the EA. And immediately, the first legal filing by Native Hawaiian Legal Corp, and I have it here, a letter, objected to us doing the EA. And it wasn't until May of last year that they were willing to withdraw their objection to it and start entering into discussions with us, which we said we would do, on how to approach the EA, because you can't do a full, back to an EIS, but you can't do the full EIS until you know what the IIFS are, until you know how much water, what are you assessing the impact of. But we are going to agree on certain things that you could start with on the EA, and hopefully agree to some consultants too, so that we don't just fight down the line. So we started those discussions, and one of the issues, and he's right, was that there would be a clause in it, which I think the BLNR said was typical, that if we were to do it and we were ultimately not the successful bidder of the lease, that we get paid back by whoever the successful bidder of the lease is, so that's the benefit from it. We were trying to go down that path and it broke apart. But
the reason I bring that up too is because yesterday when I heard a number of the cost of an EIS, I mean, I can only imagine how much this one would cost. So that's, I just wanted you to be able to clarify that.
In 2001, when we offered to do it and we looked at the estimate, it was over $1 million.
Okay, so in this area, how many acres are in Perkin Egglands that you folks put in when you passed the bill 6 or 8 years ago? I forget.
So in Maui, we have 27,000.
Okay, and is this water issue, how much of those acres would this, the water issue,
all 27,000 acres
are in this
served.
one area? Okay. Of those Perkin Egglands, how many could you take out via the Perkin Eggland use if you folks, let's just say you can't get the water and you can't use it for agriculture, then what do you do?
I don't think the law specifies how many you can take out. I mean, there's certain criteria for applying to the Land Use Commission to take the lands out. But the lack of availability of water is a criteria. You can't have water, you can't farm it.
And it's, you know, the reason I bring these questions up is because on Kauai, AMPEC is, you know, when they went out, they just left. And the water systems were taken over by, you know, local farmers who, you know, this is a huge, huge water system, and they couldn't maintain it. So East Kauai Water Systems, who Rep. Decoit knows very well, Jerry Ornelas, they do it on their own, and they have to come and beg over here for $75,000 a year so that they can repair the pipes and do all the work, and that's all they get. And these are volunteers. I don't know how anybody else is gonna do it on Maui. We're lucky. We're lucky that we have these guys on Kauai. But that is a huge system. So, you know, these are all of the repercussions of some of the things that have happened with other plantation lands that have gone out. And then the other thing is the flooding that happens because there's nobody to take care of the system. And I hope that, you know, Maui learns from what happened on Kauai when sugar went out on Kauai. And that's the scary part. And then I agree 100% with Rep. Decoit with Dilinar. And, you know, I know this is a new administration and Keikoa has been, you know, a good defender of the department. You know, it's not your fault. It's not, I don't know how long both of you have been there, but, I'm sorry?
I mean, I was appointed in the end of August of last year.
8 years.
Okay. So, you know, it's frustrating. I mean, for this thing to go on that long, it's kind of ridiculous. So, it's tough. You know, you have all these farmers here, the taro farmers that come in, and obviously, as everybody probably knows, the Haraguchis on Kauai are the largest taro growers in the state. And I go to schools all the time, and I ask kids, how many kids want to be farmers? In 20 years, maybe 10 or 15 kids raise their hand, because it's hard work. And taro farmers are even a whole nother breed. So what, in the short term, I mean, people are telling us don't pass this bill. I know KIUC, they're not going to go write a letter just because somebody asked them to write it. They're afraid. They're afraid that if this doesn't happen, the 2 hydro stations on Kauai are not going to be taken out. So they're really, really afraid. And these are the people, that's all of my constituents that we represent. So I'm disappointed that nobody is here from the Attorney General's office to answer some of these legal questions. But in the short fix from DNR, what else is going on? You said you're working with your attorneys and the Attorney General, and but you know, I gotta believe from my constituents and the people at KIUC that they're not making this thing up, that this stuff is for real.
So I know of at least a couple of projects, one on Kauai where KIUC is seeking, you know, a water lease instead of a permit, to have a permanent disposition, but they'll have to go through that entire process.
And then how long that's gonna take?
It's, you know, at least a couple of years.
So, correct me if I'm wrong, and you said you're not the attorney, but the purpose of this bill was to hold over till some of the legal stuff got resolved. Is that accurate?
Well, that's how I read it. It's not a department.
It's not an end-all, be-all bill. Okay, thank you.
Okay, members, any other questions? Rep. Lopresti, and then we'll come back to Rep. Decoit if there's no other first-time questions.
Do you want to go first? A and B and Sierra Club, please. I don't even know where to begin. I feel we're getting so many contradictory statements, but I'll begin with what I think was a contradictory statement that you made. What was your name again? I'm sorry.
Meredith.
You stated we don't need the water in the interim because of what's happening, but it's essential that we have it in the interim. Could you explain that?
What I wrote. What I meant to say is, as we harvest our last sugar crop, and we only start to explore diversified egg potential, our water needs are going to be significantly less than they were when we're cultivating all sugar. But if our dream is achieved, our hope of diversified egg across the 36,000 acres, that water use is again going to go up from where it will be at the end of this year. So
Okay.
that's all I was trying to describe, perhaps poorly, a decrease and then an increase.
But then, I mean, I'm not a farmer, but I can do math, and even it seems you and your lobbyists admit that it's not going to be anywhere near what you guys need now. And then when I do the math from the water you already have access to without this extra water, you already have enough. And 132 million gallons of water a day on average are available. And then you guys have leakage of something up to 41 million gallons a day. It's not very good stewardship. It's like, the only analogy I can think of is saying, I don't have any money in my hands, give me $400 million when I got 132 million in my pocket. And 41 of that's fallen out because I didn't sew up a hole in my pocket. I mean, why is that, why am I wrong in that analogy?
131 million gallons per day, I believe, represents the entire ditch flow, so that includes the state water. So we do need, it's not just, I think, our portion. It's not what, if we don't have the leases as is threatened by this bill, we don't have 131, we have much less. Now, the 41 million of, what did you call it, waste or losses?
Well,
that's
unlined reservoirs, aging pipes, things like that is what I've been told.
That's addressed in Dr. Maiki's proposed decision as well. So the system losses are things like evaporation. So these are agricultural ditches. They're open to the air, and they run for 72 miles. So there is quite a bit of evaporation. And in Dr. Maiki's recommended decision, he calls these system losses reasonable. In fact, they're at the lower end of the scale of the U.S. Department of Agriculture's similar standards for open ditches. So I have a quote from a page from his decision.
Okay, so Sierra Club, help me understand some of the opposition that's suggesting that many of the opponents are saying that they do have enough water. And she just said, well, that's not enough water.
Dr.
Yeah, please.
Dr. Maike, I've actually read his entire opinion, and because Sierra Club was a witness in the contested case, and we provided substantial testimony about the uses of the water. What he suggested is that already, even if they continue to grow sugar, HCNS could successfully grow sugar if 30 million gallons a day of water of what they are currently diverting was returned to the streams, to various streams. That included some water that had already been previously promised to be returned, but when it was actually measured, that water was not returned in the volume that was promised in most locations. A few locations it was, but most locations it wasn't. So he suggested two things. He suggested, first, we fulfill our first set of promises from 2008. Secondly, really, these folks have had a chance to tell us more about what their needs are, and they are entitled to more. And I've evaluated what the numbers that were given me by HCNS, and he just frankly said, your demand is being overstated, and you could successfully function on less water. So he said there was enough water to share. And there's significant amount of information about how much water goes where, this or that, that are in these reports that the Commission on Water Resources Management prepared before Mr. Pearson was involved with them. You may not be aware of them, but Sierra Club has tracked this since 2001. We were there testifying, and we've tracked every report, written comments on every report,
And I've usually been the person who wrote those comments, so that's why I came up here to chat with you folks. So there's a volume of information. What is missing from this information are a few key things. We do not actually know how much is diverted individually from many streams. We used to have like a large number of gauges on East Maui streams. It's now dwindled down to I think 3 or 4, and there are some temporary probes in a number of the streams that are recording the flow levels, but they're not recording what's diverted. So that's a big question mark, how much is taken. It's measured at one point at Holdover Stream at the far western end of the system. And the system extends, 30 miles out to Nahiku. So we don't know stream by stream what's being taken, what's being lost in between in the streams. We have these estimates. But we do know that at the end, there's average amounts that end up at that Holdover and that are gauged that then go on to Central Valley fields. And Dr. Maike just felt that there could be a different adjustment if sugarcane was the crop. Now, he never considered what the adjustment would be if sugarcane was not the crop. So that's something that needs to be taken into account. And also, the county uses part of that water, but they use part from the system that services the sugarcane fields. Part that they use is their very own system that only goes to 5 streams, 2 separate pipelines, and it is a separate system. It is maintained by A&B. The county pays A&B to maintain that system and to deliver water to them, and that covers the entire cost of maintaining the entire ditch system. So we would not have a Kauai because the county of Maui needs that water, and they pay several $1 million a year, which covers the cost of the 15 to 18 employees. I get this from the records, and Ms. Ching can, chime in if she wants, but the county gets a great deal on the water, and they're happy to pay for a very reasonable delivery fee of 6 cents per 1,000 gallons, and their fees cover the maintenance of the system. So I don't think those fees are going to go away because the county's going to continue to use that water.
Yeah, well, I appreciate that. Another aspect is going back to what the former representative asked about, of these other parties coming in and being very concerned that this bill would affect them. But when I look at the transcript from the court hearing, the judge is even pretty clear that this doesn't affect the hundreds. It would only affect this one particular case, that is with A&E. And I find that very confusing. I don't understand, and I don't know that it's appropriate that we have a legislative solution to this, given all that's going on. And I honest to God, can't see any reasonable explanation as to why you guys need way more water than you're even admitting to needing. And it just seems really, I don't, maybe it's just me, but I'm sure you have communication experts who can help you with this. I don't know if you understand how unreasonable you appear. But that's...
Yeah, I'm sorry if we do appear unreasonable. We're not trying to be. If you do simple math of 36,000 acres, if you're trying to keep this in agriculture, diversified ag is 3,500 to 4,000 gallons per acre per day. You get up to...
I think the Water Commission ruled it was 2,500 gallons of water per day for agriculture.
I think there's a couple standards in there. There's also 4,000 gallons per acre per day. So you take that, that's like 130 to 140 million gallons per day of water.
I think
we don't.
Sorry, so I want to make sure Rep. DeQuaid has time to ask questions. It's her district, and I want to support her as much as I can. So I'm sorry to cut you both off. But thank you, Chair.
Okay, members, any other questions? Okay, we'll go to Rep. Jordan, and then we'll go a second.
Oh, I'm sorry.
Rep. Jordan.
I guess it would be DLNR, maybe somebody from the Water Commission. And the Water Commission is under DLNR, correct? Is the Water Commission under DLNR?
Yes.
Yeah, sorry, I'll sit on the bracket. So I mean, it's kind of crazy. Sorry, I gotta get back to my notes. You know, listening to the testimony and hearing it's been taking such a long time to get where we are here today. And hearing the difference of interpretation of what our public trust is and use of the water. You know, 174C-2 clearly says, however, adequate provision shall be made for protection of traditional and cultural practice, customary Hawaiian rights, and the protection of procreation of fish and wildlife and the maintenance of proper ecological balance and scenic beauty. I mean, that's what I think what DLNR is embedded with, right? And hearing the many testimonies, I think that's what the root of their testimony is about. I hear what you're saying. There has been a change in operations at this corporation since the ruling. I too don't believe this measure is needed at this point in time. I think we should wait and hear what these oral arguments are going to be to see if there's going to be a difference. I mean, I'm glad the DLNR has moved forward with the task force. Unfortunately, I don't know why we haven't addressed it sooner. And I don't know why we haven't addressed it much earlier at the Board of Land and Natural Resources level, and why we haven't addressed why we have this big gap in our statutes. And it's come to this point when we're hearing clearly people who would like to practice are no longer able to do that or walking away from it. And I mean, this is near and dear to me. I'm not from Maui. I represent the west side of Oahu, but clearly Wakaha Valley has no more ului at all because of a public utility pumping the line. As you heard in earlier testimony, Kuea in Waianae Valley has very little kalo being produced by Ka'ala Farms, who in essence took their rights to the water. And I think we really, as a state, should start looking at what we have in our Constitution, our documents, unfortunately. And I truly understand what A&B's issues are. I don't know how a company could be operating for the last 13 years and trying to keep infrastructure up with a revocable permit. I mean, even in normal business standards, that's very difficult. It really, really is. So I'm hoping that maybe, you know, this body could really shelve this at this point in time, and maybe we'll see some resolution. And I know you're gonna work fast and furiously on a task force, but that's gonna be right at the end of our session. And I don't think we're gonna be able to achieve anything during this, and I don't believe we'll come into a special session at this particular year. So unfortunately, I think we have to put our faith in our department, who has unfortunately failed us the last 13 years. But I'm going to put my faith back into our department, which is DLNR, and hopefully you. I think I made my stance loud and clear already on this particular measure by saying, you know, hopefully we'll get something done that benefits all. So I don't know if you want to respond, but that really wasn't a question for you, but I'm hoping with, you know, I mean, I think there was 2 studies already done for the inflow streams that were kind of thrown back. Hopefully we're going to do a 3rd one, but at some point in time, can we at least move forward with some of the EIA or EIS process without waiting for this document before we can start this discussion? Can some of that start happening at this point in time?
We'd like to reinitiate discussions, but I feel compelled to defend them a little bit, and I can give you a timeline. It really wasn't the DLNR's fault in that there was a litigation after litigation after litigation. So these 2 in-stream flow standards that you talked about, studies, they were made in 2008 and 2010, And then there was a lawsuit to do the whole process all over again in a contested case hearing format. And that took 6 years until January when Dr. Miike came out with his recommendations. So I think we all support processes, right? That's supposed to lead to better decisions. But in the meantime, people shouldn't be penalized for allowing the processes to occur as they do. And again, I can give you a timeline that shows all the various court filings and procedures that were requested and granted. That's what's taken 15 years.
But in the meantime, weren't we able to provide some extra water for what I hear is traditional and cultural practices?
Yeah, there were releases made at least 2 different times. There was an interim order by the Board of Land and Natural Resources, I'm going to say around 2007, and water was released to the taro farmers. And then when the decision, the 2 IIFS decisions in 2008 and 2010 were made, we complied with that decision, even though it was being litigated. It was going to go through a contested case hearing again. Now, Lucian Denai said we didn't put as much water as we were supposed to, but we lifted it up the gate. Everything was going. What it was is what was estimated to be there was not what was actually there. And Dr. Miike's decision clearly recognizes that they use a theoretical flow, and when they actually went to measure it, it wasn't there. And he's going to adjust for it in this decision. But it wasn't because people were holding back water. Water Commission staff approved every implementation of the releases that we did, even though again the decision wasn't final, it was being litigated. And it just, the water wasn't what they thought it was going to be.
And that was due to maybe rainfall?
No, it's just use a theoretical, they use a theoretical median flow and the base flow 50, and it's kind of a calculation instead of an actual measurement, but once the releases were made, they started to actually measure it, and yeah. And sometimes it's rainfall. I mean, you've heard a lot about how there's been less and less water. That's been true for all of us. When we look at our long-term median ditch flow, it's gone down 20% over the last 10 years or so. That's just natural rainfall. There's less of it.
Well, I don't mean to beat up on my department, or the state's department, or water commission, but, you know, I mean, these are all long-standing, not just this issue. There's many, many long-standing issues revolving around public trust. And if these waters are coming off public lands, we should be careful with what we're doing. And I know this was preceding all of us, preceding a lot of other things, but at some point in time, we gotta start aligning ourselves with that public trust doctrine.
I think I could make well, as far as the task force, even if we don't get to the point of the legislature possibly passing something, I would like to think that we're going to do a lot of progress, and we can do policy or internal procedures that are going to help fully clean this process up to the best that we can. If there's laws that we needed, maybe they can come at a later time. But I'd like to think we're going to be able to do our job without the help of you, at least for now, and clean up the process and make it more transparent. And, you know, answer some of these questions that you asked, or attempt to answer some of these questions to make the process better in terms of coming to the legislature. As far as the contested case for the streams, I know that Larry, the hearings officer, Dr. Miike, there was a resolution on some of the streams as far as the interim in-stream flow standards. When he took on this contested case, he decided to take in all the streams and kind of look at the whole thing as a big picture, as opposed to piecemealing it and, you know, leaving out what was already addressed. So I think you give him credit for that he made the decision to look at it in the big picture. I can't predict exactly what's going to happen. The decision in order, I think from hearing other people evaluate it, they said there's going to be an additional 18 million gallons in the streams based on Larry Miike's assessment of revising the interim in-stream flow standards. He's looking at revising them to meet all the requirements of the public trust, and streams, of course, is in there, and taro farms are in there, and he's very aware of it, and he takes the water code on every stream that he evaluates and tries to look at all the issues that are involved that were read off earlier, to evaluate what amount of water should be in the streams. So if we can make an assumption that the Water Commission, when they review this decision in order, after the exceptions and the oral arguments, there's going to be more water in the streams, most likely. Besides that, Mr. Miki said very simply that if HCNS uses less water, which you've said they likely will use less water, they can't divert the same amount of water and use less water, because that would be considered waste. If they're not using it, it's waste. So if they don't divert this water and they use less water, fill in the blank, where would the water be if it's not diverted and they're not using it? It should be in the streams. That's really simple, and it's not that easy, because there's 27 streams, some streams aren't even diverted. There's going to be methods to make sure you get the water in the streams if there's going to be less water in the ditch. But the simple statement is, if they use less water, there should be more water in the stream. So that, I don't know if that's not the end all, that's not solving everybody's problems. I know Larry and everybody else, myself included, are well aware of the taro farmers, and so that's very important. So, and with more water in the streams, I think there will be, that issue should be addressed, at least at a better state.
Thank you, Chair.
Members, any other questions? The Chair wants to remind you, we spent over 3 hours on this one bill. So please, let's keep our questions focused, and if there's no other questions for the first round, I'm going to go directly quick. Directly quick.
Thank you, Chair. So I just wanted to follow up, and I think that's what we are talking about, public trust and being able to trust. I think that's a big thing for a lot of us here. I think what we gotta really focus on is how much is enough. We want to help out taro farmers. I'll use an example of Molokai. Many years ago, we came into also our own lawsuit with the Molokai irrigation system on priority water rights for its Native Hawaiians, and 2/3 of water rights. And you see what was posed to us as farmers on Molokai by the department here on Oahu. 2/3 of nothing is nothing. That was pretty tough. At that time, we had Native Hawaiian Legal Corporation defend us. It's something that still hasn't been resolved today, which is why I say the hardest thing for a lot of us right now is to bite the bullet by saying, who is it within the permits that this thing is addressing? Because you have neighbor island people that are questioning per the AG's response to this. That's the thing right now. Is it actually affecting them? And in the meantime, while we try to keep our crops watered and continue to do diversified ag, we cannot do it. We cannot do diversified ag. The amount of water you guys draw, I do have a problem, but I do know gray water cannot be used on the diversified ag because of food safety. I'm very well knowledgeable about water as a farmer, as a rancher. I know a lot about water rights. So to have a department tell me we're gonna work on it, I really don't want too much trust, and I'm sorry, Kiko, kind of like, and you're very appeasing when we ask you. But I have to tell you, flow levels, flow in streams, if that's the case, why hasn't it been given back? And it's not just that. It's one, is we have to look towards the department. Maybe there is a blockage within the streams itself. So, this offers us the opportunity to look at all of that. It's not to throw any one person under the bus, but at the same time, those families in East Maui that have farmed and we saw them leave. It is a big thing that lies over this committee, and knowing that the information that we get is pure and clean without the conflicting stories in between, and it holds a lot on your guys' department with DLNR and Seaworm. And I'd just like you guys to take that to heart, because there are gonna be a lot of people impacted by this and the precedent that we're gonna set for our neighbor islands, as well as especially East Maui. So that's all I really have to say, Chair, and thank you.
Okay, thank you. Report.
I'm
Other
going to turn it
questions?
into a question. Could Sierra Club also join us? But for DLNR, the stream flows, is it the kuleana of the department to have actual gauges? I know the notion that we were doing estimations and extrapolations. Are there actually going to be gauges? So when Maiki says, this is the amount of flow, that will have been an empirical, evidential piece of data, not just theoretical.
I don't know about the details of the amount of gauges, but I know that staff goes out and analyzes right now for Navaeha quarterly, looks at the stream flows where the diversions are, allowing more water to verify that there's a flow in the streams as determined in the mediation in that case.
So we should be able to quantify.
We should be able to
the
quantify.
amount.
It's a lot of streams and a lot of area and a lot of time, and I can't say it's going to be 100%, but I think, yeah, the commission will do their best to quantify that.
That would be very helpful.
The movement is being
The
done.
question of the Sierra Club is, in Montalvo Bay, in my district, we have a problem with non-point source pollution. We get all the rain and it goes through the marina into the bay, and 80% of our problem is killing the coral, etc. Do we know, or could we possibly know, how much water is coming, diverted, and then what actually ends up into the ocean? Because to me, that's the waste, when it just goes out into the ocean. If we're denying farmers or other land. Do we have any, just a guess?
First, I'd just like to make clear that a stream running into the ocean is not water wasted.
It's polluted in the sense that it's for farmers if they can't use it.
So I
That's what
think the issue in Monolua Bay has to do more with the armored shoreline and the channelized streams than anything else. Basically, we took the streams of that area and we turned them into stormwater drains. And that's why you have a rush down of really polluted
It's
water.
called
Doesn't-
people living in neighborhoods, yeah.
So,
But is there anything about the streams going into the ocean?
These streams are not channelized. These streams are in their natural state. There's a lot of percolation that happens. There are springs that add to the water. There's evaporation that happens, and the streams doing what they're supposed to do, run into the ocean and provide for a whole ecosystem that we all need to survive.
So we don't know what the diversion factor is.
I don't think there's going to be a polluted stormwater runoff like you have in urban, no.
No, I only meant simply volume and what would be up there, and then what would be diverted for farming and for diversified ag versus then what would be at the end.
I think we should wait for Dr. Mieke or for the Water Commission to rule on that.
That's why I want to see if there are gauges.
Yeah, Dr. Mieke did set some in-stream flow standards that were further along towards the terminus of some of the streams, not all of the streams. It just depended on the stream and the nature.
Sounds like he's got a handle on it. Thank you,
Yeah.
guys.
Okay, thank you, members. Any other questions? Okay, seeing none, let's move on to House Bill 2235, DLNR. 2235.
Thank you. The department stands in support of this measure.
Okay, thank you. Holdover Advisory Committee. Office of the Mayor, County of Hawaii. UPW. Hawaii Fishing and Boating Association. Takeo Izawa. David Bateman. Okay, members, we've got a bunch of testimony, all forms type testimony. It's in your packet for review. Anyone else wishing to testify on this measure? We're on House Bill 2235. See none. Members, any questions? Okay, Rep. Jordan. DLNR.
I was kind of just glancing at your testimony, and you're saying that the department feels it is time to move the small boat harbors program into a new direction. Could you kind of talk about that just a little bit, what the new direction might be?
Thank you, Rep. Jordan. I'm here for Ed Underwood, who unfortunately isn't be able to be here today. I'm Megan Stacks. I'm the Oahu District Manager for the Division of Boating. The area that the boating division is talking about going into is touched a little bit in the testimony that is presented before you, and that is coming up with a public-private partnership or running private harbors. And that's something I think that Mr. Underwood has spoken with a number of members in regards to.
So, before coming to this body, I distinctly remember the Department of Land and Natural Resources body coming out to our community and talking about improvements to small boat harbors and talking about increasing certain type of fees. Some harbors having coin-operated parking, some operations, that have fees. And community members coming and testifying and saying, can some of those fees remain within a small harbor? Or what are you gonna do to improve our harbors? And the department saying they don't have enough money to improve all the harbors. And I remember hearing this major pushback from the community and the user of the small boat harbors and saying, do not privatize our small boat harbors. You know, obviously, Megan, I work with you a lot. I have a small boat harbor within my district. You know, and we have challenges. One of them being a harbor master, which I don't believe we still have one. It's not what this measure addresses. But how do we maintain? Because we hit the news a couple months ago when one of our piers collapsed. You know, what is it that maybe a private entity may take over versus the state still be responsible? Now, just down the road from me, we have this private harbor called Ko'olina. And when you talk about people using our public small boat harbors, their fees might be very small, the mooring fees versus a private harbor. Comparing ours to Ko'olina down the road, Ko'olina is almost triple. Ko'olina had things like you're required to have insurance and other things at that point in time, which the state has changed their rules, and now we're required to have insurance on vessels and items like that for protections. But at some point in time, when do we start giving public spaces to private entities? And I'm very nervous about these type of programs with public-private partnerships. So I find it interesting that the department's saying we need to start looking at the new direction when clearly I think some of that public outcry back then was like, please don't even do that. So have we gone out to any type of public meetings to kind of get a new pulse of the community? Because I think that was probably like about 8 or 10 years ago that I attended some of those public meetings to kind of get a new feedback from community on probably privatizing some of our small boat harbors.
I think the reason why this was put into this is because we have asked for more positions to do 7 days a week, and that's kind of been the push that we've gotten back from the community. You know, our small boat harbors statewide are only Monday through Friday. And unless we get more staffing, more positions to work 7 days a week, which unfortunately we're not getting, there has to be give and take someplace. So I think that's the reason why talking about going and working with a private company who doesn't have to go through what we have to go through with, you know, Rep. Jordan, we talked union issues that we've had, a lot of the CIP funding that we have to go through in order to get these repairs done, and some of the permits that we have to do. So ideally, it'd be nice to have enough positions so that we are working 7 days a week. If we can't get that, then there has to be some sort of other ideas that are coming through in order to support the small boat harbors.
Okay, so at what point in time does the community have an input in which ones will be selected, or will they all be selected, or we just won't have a voice in it? I can see maybe Alawai privatizing, great revenue generator. Waianae, Haleiwa, I don't get it, because my closest small boat harbor would be Haleiwa. You know, where does everybody from central to the west go for a private harbor to launch their jet ski or their boat or my weekend fishing warriors, you know? That's without getting the sense of a Ko'olina feel. And if you haven't been to Ko'olina, you're greeted entering their private gated community, which shouldn't be private, before you even get to their harbor mouth. You know, when is when, because, and I'm talking about everything, right? When our fishing community really wants to have that flexibility to go, and I understand, I've watched 6 years of you guys coming here pretty much begging for the smallest share of our general fund dollars with the biggest task in the state on our public resources. I get it. You gotta have to start making some tough decisions. I'm not, and you've already heard me say I'm not supportive of privatizing our small boat owners. But I don't know where we begin. I don't know if it's this measure or the department starting to have public meetings to really get good input on where we should go, instead of unilaterally waiting every time something changes new in our administration, we get a new direction. I mean, I'm just a little cautious with that.
Understandably so, Rep. Jordan, and this is not our...
Yeah, I understand.
Okay. Thank you.
I understand. Thank you, Chair.
Members, any other questions? Okay, seeing none, let's move on to House Bill 1041, DLNR.
Thank you, Vice Chair, members of the committee. Again, Keikoa Kaluhiva, First Deputy for DLNR. We stand on our testimony in support of this measure. However, we'd like to make one recommendation. It is substantive, but we wanted to note it for the record that Chapter 13-124, which regulates indigenous wildlife, endangered and threatened wildlife, that be struck from this current draft. We had actually requested this in prior committees, but somehow it still was kept. And I would like to just say we would like this struck because we don't believe this should be under the purview of a game commission, having indigenous wildlife be part of that. And that's actually in agreement with the hunting community that we would have that struck. So thank you very much.
Okay, thank you. Ahamoku Advisory Committee. Hawaii County Council, Miley Maderas David. Office of the Mayor, County of Hawaii. Hawaii Crop Improvement Association. Hawaii Farm Bureau. Mark Bartel. Society for Hawaii Heritage Animals. Okay, members, we've got a bunch of testimony from people who said they will not be present. It is in your packet, so let's call up anybody right now who is here to testify on this measure. Come up. Okay, members, any questions? Thank you. Seeing none, let's move on to the final measure, House Bill 2036. DLNR.
Hello again, Vice Chair, members of the committee, Keikoa Kaluhiva, First Deputy of DLNR. Just stating for the record, we do support this measure, basically saying that this would help us assure that the public's right to due process is protected. Thank you.
Okay, thank you. Hawaii Island Economic Development Board. Hawaii Leeward Planning Conference. Chamber of Commerce of Hawaii. Ross Wilson Jr. Kona Kohala Chamber of Commerce. That's all the written testimony we've received. Anyone else wishing to testify? Members, any questions? Okay, seeing none. We're going to do decision making on this agenda Tuesday at 11 o'clock. We are adjourned.